Good morning. You'll probably notice I'm not Dara Keogh, our president. I'm Anne Sinnott, the deputy president, and it's my very great pleasure to extend a very warm welcome to everyone joining us in person and online, including many in Ukraine, Strasbourg, and elsewhere. I want to extend a particular welcome to Minister of State, Thomas Byrne, Poland's Deputy Minister for Justice, Dariusz Mazur, His Excellency Bjorn Berga, Deputy Secretary General of the Council of Europe, Professor Siofra O'Leary, former President of the European Court of Human Rights, Professor Michael O'Flaherty, Council of Europe, Commissioner for Human Rights, Professor Jörg Polakowicz, Legal Advisor, Director, Council of Europe, apologies for my mispronunciation, Dr. Anton Koryniewi, Ambassador at Large, Agent of Ukraine before the International Court of Justice, who's joining us online, and Her Excellency Larissa Garasko, Ambassador of Ukraine to Ireland. We gather this week, 3 years on from Russia's full-scale invasion of Ukraine, a major escalation in a war that began in 2014. It's a somber moment. Hundreds of thousands of people have died. There's been enormous suffering and conflict, which are ongoing. The Trump presidency has ruptured former assumptions and alliances. Despite the uncertainty over how peace can be achieved, we must look beyond the conflict. That's what today's gathering is all about. In particular, how to achieve justice as well as peace in Ukraine. The third anniversary provides a fitting backdrop to consider the Council of Europe's role in the pursuit of peace, justice, and accountability in Ukraine. I welcome the leadership shown by the Dublin European Law Institute, Delhi, in hosting this conference. I would encourage further academic engagement with the law and policies of the Council of Europe, particularly when it comes to ensuring the effectiveness of Europe's human rights framework. I warmly welcome the establishment of the Open Council of Europe Academic Network, OCEAN, and I'm proud DCU is already contributing significantly to this network. I also understand that Delhi plans to step up research related to the law, policies and politics of the Council of Europe, led by Dr. Andrew Ford. The work of our colleagues in Delhi on events like this one exemplifies the importance of collaboration between international organisations, national governments and academic institutions. This engagement is critical to our efforts to transform lives and societies, the DCU mission. The support of the Department of Foreign Affairs in helping us to deliver this event is an example of the positive outcome of such collaborations. My thanks to everyone involved on the success of today's event, the Department of Foreign Affairs, our keynote speakers and panelists, Ambassador Garasko, Professor Federico Fabrini, Dr. Andrew Ford, and wishing you a productive and engaging day. Thank you. I should have been Dara. I'm not doing my job very well. I need to invite the Minister now to come up and address us, please.
Thanks very much, and thanks for the invitation. I remember when I was a very young politician, myself and the late Deputy Shane McEntee were told we weren't welcome at a public meeting, and we told the parish priest who was organising the public meeting that we didn't need an invitation. So that as TDs in the area, so that thought just rolled back. That's a long time ago now. But thanks very much for the invitation. Deputy President, Deputy General Secretary, Commissioner Flaherty, professors, excellencies, ladies and gentlemen. I want to thank the Dublin European Law Institute at DCU for hosting this really important conference in person and online. The last time I think I addressed DCU was online in COVID. So I'm really glad to be here today in person for what will be a very informative and insightful discussion on such an important issue. On Monday, of course, we marked the third anniversary of Russia's brutal and illegal full-scale invasion of Ukraine. And over the past 3 years, the people of Ukraine have endured unimaginable violence and suffering, the destruction of homes, livelihoods, and critical infrastructure by Russia. Yet they continue to demonstrate remarkable courage, resolve, and determination in the face of adversity. Indeed, President Zelensky will be in Ireland briefly today and talking to his Deputy Prime Minister, who is, I think, accompanying him last week in Poland. The resilience that they're showing, the continuing resilience that they're showing, is just incredible to behold. In seeking to change borders by force, Russia is challenging principles that we've all signed up to as UN member states, respecting sovereignty and territorial integrity, and the rights of all nations and peoples to choose their own paths. But Russian actions have also directly impacted countless Ukrainian lives, tearing families apart, destroying lives and livelihoods, and causing immense human suffering. Ireland is a militarily neutral country by tradition, but we've never been politically or morally neutral in the face of violations of international law and the commission of international crimes. In fact, the opposite. Our position is informed by the principles that drive our foreign policy: support for human rights, for international humanitarian law, and for the rules-based international order. We recognise that as Ukrainians defend their nation, they are defending our fundamental European and universal freedoms, the rights of all peoples to live peacefully within their own borders without fear of being attacked. So this is an existential issue not just for Ukraine, but also for the security of Europe. And how we respond has far-reaching consequences. It's a moment when Europe needs to stand together in solidarity with Ukraine and in defence of our European values. Ireland's support remains as strong today as it was on day one of Russia's war. Since February 2022, Ireland has committed over €380 million in support of Ukraine. This is focused on humanitarian and stabilisation assistance, alongside non-lethal military support and strong political support, including for Ukraine's European perspective. We were among the first member states to support an accession process for Ukraine. And included in some of the support that we're giving to Ukraine at the moment is one example is a joint effort we have with Lithuania, where we're providing bomb shelters for schools. And I think that starkly illustrates the current necessities that are there in Ukraine. We will continue to work with our EU partners to ensure that Ukraine gets the support it needs to defend itself against Russia's ongoing illegal invasion, in line with Article 51 of the UN Charter. And we look forward to next week's special meeting of the European Council, at which EU leaders will consider further proposals for much needed support. President Zelensky, of course, has made clear that nobody wants peace more than Ukraine. And we all want to see an end to this invasion, an end to this conflict, and we want to see peace in Ukraine. But how we make peace matters. There can be nothing about Ukraine without Ukraine. Equally, there should be nothing about Europe without Europe. Together with our EU partners, Ireland will continue to build global support for comprehensive, just and lasting peace on Ukraine's terms, which upholds Ukraine's sovereignty and territorial integrity, and which is based on respect for the principles of the UN Charter and international law. And we know that for any peace agreement to last, it must have justice and accountability at heart. That's why Ireland strongly supports efforts to hold the Russian Federation accountable for its aggression against Ukraine, which of course represents a flagrant breach and violation of international law. This includes support for the investigations of the ICC prosecutor in Ukraine and our participation in the ongoing efforts of the core group towards the establishment of a special tribunal for the crime of aggression. I'm conscious that when Ireland found itself in the eye of the Brexit storm, and I'm not comparing Brexit to an illegal invasion, but it was at the time it was pretty intense in terms of our diplomatic efforts. But EU member states furthest away from our own borders and all those in between never wavered in their solidarity for Ireland. And I actually very much remember going to Latvia and meeting the chairman of the European Affairs Committee there, and his knowledge and depth of understanding of the situation on the island of Ireland was simply incredible. And that was repeated across the continent. So at this crucial juncture for Europe, and as we look ahead to our EU presidency in 2026, Ireland must demonstrate the same solidarity with our European neighbours. And indeed, when we have the presidency and the run-up to it, we're not just driving forward an Irish agenda, but we're driving forward the common agenda of the European governments at the Council of Ministers. And we must demonstrate our understanding of the urgent needs of our fellow member states when it comes to their security and defence. I know that we can do this in a way that recognises the needs of other member states, but without undermining our own traditions. And that includes enhancing our own security and defence. The Council of Europe, of course, has a very important role to play at this critical juncture. Ireland is very proud to have been one of the 10 original signatories of the Treaty of London in 1949, which established the Council of Europe just over 75 years ago. And it's always worth reminding people as to why the Council of Europe was established, when it was established, and who were those countries establishing it, because it tells a good big story. And during my last term as EU Minister, Ireland took over the presidency of the Committee of Ministers in May 2022, at a critical time in the history of the Council of Europe. And I think 3 years on, the impact and legacy of our presidency remains. A highlight of our presidency was securing the decision by the Committee of Ministers to hold only the 4th ever summit of Council of Europe Heads of State and Government. And this was held in Reykjavik in May 2023, and the leaders made the historic decision to establish the register of damage caused by the Russian Federation's aggression against Ukraine, which is an important step in the path to accountability for crimes committed in Ukraine. We are now engaged in discussions on establishing a claims commission to compensate Ukrainians for Russia's reprehensible actions. I'm very happy that the Deputy General Secretary of the Council of Europe, Mr. Bjorn Berg, is with us here in Dublin today to address the conference. I mentioned earlier that last year marked the 75th anniversary of the establishment of the Council of Europe. And indeed, the Deputy Secretary General was instrumental in leading efforts within the institution to highlight the important legacy of the Council across our continent through his Visibility Days project. Highlighting the valuable contribution that the Council of Europe makes to the defence of democracy and human rights in Europe is all the more important at a time when our multilateral institutions are not only under sustained attack, but also under another form of attack where some people start to ignore them or use them in ways that are not helpful to the greater good. Recognising the critical importance of the Council of Europe to our progress and development, the Department of Foreign Affairs has organised for 32 students from across the island to travel to Strasbourg to learn about the work of the Council of Europe. We're deeply thankful to the Deputy Secretary General for taking the time to meet with the students for a very open and frank dialogue. Also here today, of course, Michael is here, Michael O'Flaherty, there, yeah, who is the Council of Europe Commissioner for Human Rights, and Professor Sifa O'Leary as well, who's the former President of the European Court of Human Rights. Our bond with the Council of Europe is extensive, long-standing, and clearly evident by the strength and influence of Irish representatives across the institution, and indeed the institution's influence on Irish life as well, whether it's the court and its various judgments and the significant impact that court has had, but also the Council of Europe itself and the general principles that are there that we've respected, that we've interwoven into our laws and interwoven, of course, into the peace agreement in Northern Ireland. And today's conference is another example of the Council of Europe's input and influence in Ireland. And I think you are hearing today from a very impressive and distinguished group of speakers. Finally, as we sit here in Dublin, we recognise and honour the immense sacrifices that the people of Ukraine are making in their brave defence of freedom and democracy. They want the democratic, good life that we have in the rest of Western Europe, and they're entitled to it. And we will continue to stand with the Ukrainian people for as long as it takes in their pursuit of peace, territorial integrity, and a prosperous future within the European Union. Gramadov.
I just want to thank the Minister for those opening remarks. My name is Derek Hand and I'm the Dean of the Faculty of Humanities and Social Sciences, and I just want to thank my colleagues for giving me the opportunity to invite you here this morning and to welcome you to this really, I suppose, relevant and impactful gathering. My first duty is to invite the Deputy Ukrainian ambassador, Dmytro Shedorin, to say a few words.
I'm really sorry I'm stealing the pleasure of talking to my ambassador today from all of you, but obviously if you check your Irish Times app, you can see that she has to be elsewhere today. I'm really honored to be here. Thank you so much for coming. Minister, thank you for your kind words. And obviously I extend my gratitude from the ambassador for your yesterday address in Doyle. You know, words of support for Ukraine and solidarity are always powerful demonstration that Ireland stands with Ukraine, and I thank you for that. Dear Minister, Excellencies, Commissioner Flaherty, Deputy Secretary General, distinguished guests, dear Vice President, Deputy President, it is both an honor and privilege to address you today at this conference, which seeks to explore the crucial role of the Council of Europe in pursuit of peace, justice, and accountability in Ukraine. As we gather in Dublin, we reflect on the immense challenges Ukraine faces in the wake of Russian aggression, an aggression that began 11 years ago. On Monday, we marked the 3rd anniversary of Russia's full-scale invasion of Ukraine. 3 years ago on this day, our world was forever changed. A war that has simmered since 2014 erupted into unprovoked, unjustified, and unlawful full-scale invasion, driven solely by morbid geopolitical delusions of the past. This war, the bloodiest in Europe since the Second World War, has made all of us targets. Ukraine and its people are under attack because Russia denies our very right to exist. This war is not merely an international conflict. It is a brutal assault on the fundamental principles that define our common humanity: democracy, sovereignty, and human rights. It challenges the core values we hold dear as members of the international community. Yet, Ukraine has demonstrated remarkable resilience. It challenges, yes, Ukraine stands firm against the aggressor, and we remain steadfast in our commitment to achieving peace, justice, and accountability for crimes committed during this war. Unfortunately, the United Nations itself is under attack, as Russia has flagrantly violated the very foundations of the UN Charter and its core principles. Russia seeks to replace a world governed by international law with a world ruled by only force. This war is not just about Ukraine. It is a calculated effort to destabilize democratic nations, spread autocracy, and undermine the values that unite us all. The involvement of the Council of Europe in addressing these challenges has been invaluable. At the Reykjavik Summit of Heads of State and Governments in May 2023, the member states of the Council of Europe affirmed that there cannot be lasting peace without accountability. The declaration remains profoundly relevant today. Significant progress has already been made, particularly with the establishment of the Register of Damages caused by Russian aggression against Ukraine, which lays the groundwork for justice. However, we must turn our focus to ensuring that those responsible for heinous crimes of aggression are held to account. How do we guarantee that Ukraine's pursuit of justice is not confined by the limitations of national mechanisms alone? The turbulence we see in the global politics underscores the urgency of this question. One of the most pressing priorities is the establishment of a special tribunal for the crime of aggression. This is not merely a matter of legal technicalities, it is moral imperative. The crime of aggression must not go unpunished. We must ensure that those responsible face the full force of international justice. This is not just Ukraine's fight. It is a fight for the fundamental principles that sustain peace and security for all nations. For Ukraine and its people, the establishment of the Special Tribunal is a matter of the highest priority. Accountability for the crime of aggression is the key factor in securing a just, comprehensive, and lasting peace. There can be no immunity for those who have unleashed the most aggressive war in Europe since the Second World War. The Council of Europe's unwavering commitment to justice, human rights, and the rule of law has been evident throughout this crisis. Yet much remains to be done. The ongoing war continues to inflict untold suffering on Ukrainian civilians. In establishing an effective and unified legal framework for accountability remains a pressing priority for the international community. That is why today's discussions are so vital. This conference provides a critical opportunity to examine the role of Council of Europe, assess its existing mechanisms, and explore the potential for a special tribunal. We must strengthen justice and accountability mechanisms, ensuring that impunity has no place in our world. We welcome the decision of the Committee of Ministers of the Council of Europe adopted on the 30th of April 2024, authorizing the Secretary General to draft texts for a bilateral agreement between Ukraine and Council of Europe on the establishment of the Special Tribunal for the crime of aggression against Ukraine, as well as the Tribunal Statute. The decision signals the Council of Europe readiness to take an active and direct role in this crucial endeavor. It is promising development that deserves further exploration within the framework of the core group. The latest developments in the world are resulting in a fragmentation of different international partnerships. The unity of international community is essential to ensuring that peace and justice ultimately prevail. Ukraine is not alone in this struggle. We are supported by our partners, by organizations like the Council of Europe, and the unwavering solidarity of people and governments across the globe. Together, we must build a future in which accountability for crimes is inevitable, and where peace, dignity, and human rights are restored, not only in Ukraine, but in all nations suffering from aggression. Ukraine, Europe, and the world need a comprehensive, just, and lasting peace in accordance with the UN Charter. In closing, I want to express my gratitude to the Dublin European Law Institute at DCU and all the organizers for facilitating this crucial discussion, as well to the GFA for supporting this important event. I look forward to the rich exchanges and ideas that will emerge today, and your contributions will be vital as we continue to chart a path toward justice and peace for Ukraine. Thank you, and Slava Ukraini.
Thank the Deputy Ambassador for those remarks. I just want to introduce our next speaker, His Excellency Bjorn Berg, the Deputy Secretary General of the Council of Europe. Bjorn has served as the Council of Europe's Deputy Secretary General since the 1st of March 2021. Before taking up this post, Bjorn was Director General and Secretary to the Committee of Ministers of the Council of Europe, and prior to that, he served as Director of the Private Office of the Secretary General. He has over 30 years of international professional experience, including as former Norwegian diplomat, advisor to the Prime Minister, and as Deputy Director of the Foreign Minister's Cabinet, responsible for parliamentary matters. He has also served as speechwriter to 3 Norwegian foreign ministers. So speaking to the topic for today, the role of the Council of Europe in supporting peace, justice and accountability in Ukraine, His Excellency Bjorn Berg.
A very good morning to all of you, and thank you, Professor Hand, for the kind introduction. I'm pleased to be back in Dublin, and it's an honor to share the stage today with Minister Byrne and also the Deputy Ambassador Dimitru Shederin. Having you both here speaks volumes about Ireland's unwavering commitment to Ukraine and the resilience of the Ukrainian people. 3 years into an illegal war of aggression that has challenged the global order and the place of Europe in it. Let me also thank the Vice President of Dublin City University, Professor Anne Sino, for hosting us. I also want to commend the Dublin European Law Institute under the leadership of Professor Fabrini for bringing us together at the crucial time for Ukraine and for Europe. I would also like to thank an old friend, Dr. Andrew Ford, Human Rights Commissioner, former President of the European Court, Excellencies, ladies and gentlemen. To borrow the words of Mary Robinson, Ireland's first woman president and former UN High Commissioner for Human Rights, spoken at another defining moment for our continent. We need to articulate self-definition at the time of redefinition. Because that is exactly where we find ourselves today. It can be tempting to see this pivotal period only through today's headlines. Let me briefly quote some of them. Trump and Putin stun Europe with peace plan for Ukraine. Europe is not at the table in Ukraine peace talks. Now is the time for Europe really to step up on Ukraine. Each day brings new speculation. Who will shape peace? Who will decide Ukraine's future? What will a peace look like? Just this week, not one, but two resolutions from the UN General Assembly called for a comprehensive, just and lasting peace in line with the United Nations Charter. One thing is crystal clear. Ukraine must have a seat at the table, and Europe's voice must be heard. But underneath the headlines, beyond the uncertainty and divisions of the moment, we need to take the long view. Because history has taught us that, and in the end, accountability is what truly matters. Europeans know this firsthand. We have learned a lesson and paid a heavy price throughout our history. At the Council of Europe summit in Reykjavik in May 2023, as the minister also referred to, our heads of state and government declared that, I quote, "Without accountability, there can be no lasting peace." They also reaffirmed the need for an international legal response for all the victims. The Council of Europe's response to Russia's war of aggression against Ukraine was clear, swift, and undeniable. Within 24 hours after the Russian invasion of Ukraine, the Council of Europe moved to suspend the Russian Federation. And less than 3 weeks later, on March 16, Russia was formally expelled. Since then, Ukraine has been our top priority, and in particular, accountability. And for us, accountability is guided by 3 core principles: compensating the victims for the destruction and suffering they have endured, delivering justice by holding Russia accountable and making sure those responsible answer for their crimes, and thirdly, to strengthen Ukraine's European future. First, accountability begins with reparation. Exactly on the eve of the war's 3rd anniversary, Russia launched its largest drone attack so far. And as the war against Ukraine enters its 4th year, attacks on civilians, energy infrastructure, and even medical facilities continue unabated. In response to the destruction, the Council of Europe has, together with Ukraine, launched the Register of Damage for Ukraine, a multilateral response backed by the international community. To date, we have received close to 13,000 claims for damage or destruction of residential housing. A new claims category for the death of immediate family members was introduced recently, and we are now working on several other new claims categories. You can imagine the hundreds of thousands of claims we will receive in the end. Today, the register is fully operational. But it's not enough only to register the death and destruction. You also need to compensate the victims. And the first step towards this is to establish a claims commission that can adjudicate these claims. And in this regard, earlier this month, we saw momentum build toward adopting terms of reference for work on an open Council of Europe Convention, one that would allow the broadest possible international participation in establishing the Claims Commission. As the Council of Europe, we have both the expertise and the capacity to advance this process without delay. Second, there cannot be accountability without justice. Although Russia is no longer a member of the Council of Europe, the European Court of Human Rights continues to hear and rule on cases against Russia through its residual jurisdiction. This concerns violations committed before Russia ceased to be a party to the European Convention on Human Rights. I see that former court president O'Leary will present to you the court's role in this context later in the program, so I will not go into any details. But let me just note that today over 4,500 individual war-related applications are pending against Russia before the court. They include cases related to the conflict in Crimea and eastern Ukraine, going back to 2014, not to mention prominent interstate cases. Beyond that, we have seen outrageous human rights violations since the start of the full-scale Russian invasion. And here is what that means in real terms. Russian forces have used torture systematically in every occupied area. Witnesses speak of brutality without limits. One detainee recalled being beaten while his Russian captor said, "Nobody can stop me. I will do to you whatever I want." Even those gravely wounded were denied care, left to suffer. A doctor told one Ukrainian prisoner, "You ought to die anyhow." And beyond the prisons, civilians have paid the price. Massive missile strikes on Ukraine's energy grid plunge millions into darkness. But those suffering the most are the vulnerable, the sick, and the elderly. These are real violations, documented by the Independent International Commission of Inquiry on Ukraine, established by the United Nations. This is why accountability matters. And that is why we have been working to establish also a special tribunal for the crime of aggression against Ukraine. By we, I mean a core group bringing together senior legal experts from some 40 countries, including Ireland, working alongside the Ukrainian authorities, the European Commission, and the European External Action Service, and the Council of Europe. After 13 meetings, the legal foundations are now agreed. This happened at the meeting in Brussels earlier this month. The main focus is now to set up such a special tribunal through a treaty between Ukraine and the Council of Europe. And I can guarantee you that we stand ready to support the efficient setup of such a tribunal in every way we can. Now, it's really up to the countries to cross the finishing line and summon the political will to make this special tribunal a reality, with the next gathering of the group scheduled to take place in Strasbourg in March. Third, accountability is also about upholding human rights, democracy, and rule of law, our common values. And this is the essence of our action plan for Ukraine, a plan that stands for resilience, justice, and dignity in face of unimaginable adversity and Russian aggression. Ukraine's path towards a European future is clear, and the Council of Europe's expertise is crucial in securing the reforms needed to achieve a future EU membership for Ukraine. And concrete and substantial results have been achieved. Just to mention a few. Greco, the Council of Europe expert anti-corruption body, recently noted progress in preventing corruption among parliamentarians, judges, and prosecutors in Ukraine. In criminal law, Ukraine is aligning its legislation with international standards, including on war crimes and cybercrime. At the local level, we are helping municipalities keep services running and citizens engaged, launching Ukraine's first ever citizens' assemblies. For children, we are supporting urgent efforts to identify and recover those who have been deported. Ukraine's children must be a top priority as well. And earlier this month, Council of Europe's new Secretary General, Alain Berset, appointed Iceland's former Foreign Minister, Turdis Ylfadóttir, as his special envoy on the situation of children of Ukraine. This sends the strong signal that rebuilding Ukraine begins with protecting its children wherever they are. All in all, our objective is simple: to help Ukraine reclaim its future and to restore human dignity to every Ukrainian, especially the most vulnerable amongst them. Ladies and gentlemen, each passing day, Russia's war of aggression against Ukraine takes more lives, spreads more destruction, and further undermines the very foundations of international law and the rule-based international order. As a consequence, as well as for what we have seen in the Middle East, some may ask, is the respect for human rights at the modern low point? It's a valid point to raise. And then you could add what the UN Secretary General Antonio Guterres described so well in his remarkable speech in New York last autumn. His focus was on the opposite of accountability, the other side of the coin, if you like, impunity, and the devastating impact impunity have in the world today. He pointed out that impunity is politically indefensible and morally intolerable. And he voiced his frustration that too many governments trample international law, violate the UN Charter, and ignore human rights conventions. And that they invade other countries, devastate entire societies, and disregard the welfare of their own people. And worst of all, nothing happens. This is a massive challenge that we are facing today, and it's intolerable. Dear friends, we need to continue to do our utmost to support Ukraine. We need to ensure accountability and seek ways to eliminate impunity. And last but not least, we all want dialogue and mediation and an end to the Russian aggression in Ukraine. But Ukraine needs to be at the table, and Europe's voice needs to be heard. These are the challenges before us today, and we cannot look away. Let me at the end also commend Ireland and Ukraine for making accountability an integral component of their bilateral cooperation agreement, signed last year between the Taoiseach and President Zelensky. And as Ireland prepares for its presidency of the European Council in 2026, let us use this opportunity to help ensure that accountability remains literally at the heart of everything we do in Ukraine, in Europe, and beyond. Thank you very much.
Oh. Hello.
Fáilte Corda. My name is Tanya Niverhela, and I'm the head of the School of Law and Government here in DCU. So we've just had our first game of musical chairs for the day. And I am delighted to introduce to you for this, our first panel of today, the co-authors of a very timely, wonderful new book called Russia, the Council of Europe and the European Convention on Human Rights, a Troubled Membership and Its Legacy. So could there be a more timely publication? It came out Monday, right? So bang on point in terms of what we are discussing here today. So I'm joined by Dr. Ed Bates, who's an associate professor in law at the University of Leicester. In addition to being a co-author on this book, he's also a co-author on the book that every European human rights student in law in this country and no doubt in the whole of Europe reads, which is Harris, O'Boyle and Warwick's book on the law of the European Convention on Human Rights. You have one coming out next year, which I'm really looking forward to reading, called The European Convention on Human Rights Legal System at 75, Decline, Renewal, Realism and an Uncertain Future. So that proves to be, sounds like it's going to be a very interesting book. Also with us, we have Professor Konstantin Zetziaro, who is a professor in human rights law at the University of Liverpool. Previously, having worked in the University of Surrey and the Palindrome across town, UCD, Gomel State University in Belarus, Konstantin has written so many publications that if I read them all out, we'd get nothing of substance done at all. So I'll move swiftly on to say that you have done loads of work working with international governmental and non-governmental organizations, and that you're the co-founder and co-editor-in-chief of the European Convention on Human Rights Law Review, in addition to being Director of International Law and the Human Rights Unit. Our own Dr. Andrew Ford is an assistant professor of European human rights law here in the School of Law and Government in DCU and is a commissioner on the Irish Human Rights and Equality Commission. Andrew has more than 10 years' experience of work at the Council of Europe and the Organisation for Security and Cooperation in Europe as a human rights advisor to the Council of Europe, Commissioner for Human Rights, and a political advisor with a particular focus on human rights in conflict-affected regions. And during that time, Andrew led the Council of Europe operations in Kosovo for 5 years. In the last 12 months, Andrew has published 2 books, his solo monographed book, authored monograph, The European Human Rights in Grey Zones, and this one that we're celebrating at this panel. So I'm delighted to welcome you here, chaps, to talk about your book. This is the fanciest book launch I've been at in a very long time. And I've a couple of questions to get us going, and then I'll open the conversation to the rest of the room and channel my inner Fiona Bruce on question time. She has better dresses, though. So here we go, on to more important matters. Ed, I'll come to you first. Obviously, this book, in your book, you talk about this in detail, but can you just bring us through how things deteriorated so dramatically and so quickly between the Council of Europe and Russia? Can you talk us through some of the high points and perhaps also some of the low points of that relationship over the years?
Yes, thank you very much indeed. Thank you for that introduction. Thank you for the opportunity to be here today, to our sponsors, to our hosts. Thank you. Highs and lows, highs and positives. The highs I would see as the starting point. It was amazing that a former superpower, Russia, joined the Council of Europe on the terms it did back in the 1990s, promising to stop an aggressive foreign policy, committing itself to European human rights control. These were the days of high hopes and aspirations for democratic security in Europe. We contrast this with today, of course. Highs could also include certain of the reforms that Russia put in place, particularly in the early days, which had significant impact, the abolition of the death penalty or the moratorium on the death penalty. Highs would include judgments delivered by the court in important areas such as equality, the rights of homosexuals, or important issues being addressed in relation to violence against women. Russia paid just satisfaction in many cases, most cases, in fact, I think. So there was a compensation. These are all highs, I suppose, positives to the arrangement. But it brings us to the negatives, which you are also coming to. And I've got 3 points I'd like to make there, if possible. Firstly, the idea, of course, originally was that Russia would become a democratic member of the European family of nations. Of course, it didn't, and the absolute blame for that lies with the political leadership of Russia. Of course, that's the case. But during Russia's slide away from that path to democracy, the Council of Europe institutions were able to alert this wasn't a secret. One of the aspects of our book, I think, is how we highlight how the Commissioner for Human Rights, the Parliamentary Assembly of the Council of Europe, were able to alert matters in this regard, signal issues. The European Court of Human Rights too, of course, in important rulings such as Navalny. But it's the enforcement of those rulings that was the issue. And there I go back to some of those important judgments. Were they, and Russia, for example, paying just satisfaction, disguising a reality of its not complying with core values of the Council of Europe? And let me reiterate, blame for that lies with Russia, not the institutions of the Council of Europe, which were doing their job by alerting the issue. That's my first point, the failure of Russia to go along a democratic path, notwithstanding the important contribution made by the Council of Europe. My second point is how Russia was able to exploit its big status role, big payer status, in fact, in the connection of what I've just described. Or that's how it appeared to us in this book, at least. And this may also be seen as a narrative of the Council of Europe being let down by certain of its states, not least of all Russia, but other states within it. So a narrative that could be followed there was how even in the 2000s, alarm bells were ringing in relation to, for example, impunity in relation to Chechnya, and how the Committee of Ministers of the Council of Europe did not act in that regard. The court, therefore, became a kind of last resort actor, picking up the pieces. There was reference in the 2000s even to the Trojan horse nature of Russia. So the ability here of Russia to abuse its position, and unfortunately the inability of the states to stop that. This was seen most graphically, of course, following 2014 and the invasion of Crimea. Russia then caused a constitutional crisis within the Council of Europe, refusing to pay its budgetary contributions. When PACE sought to bring some accountability in relation to Russia delegation boycotted PACE. It was a sorry tale of Russia creating trouble within the Council of Europe to a point in 2019 when, perhaps under the threat that Russia would leave altogether, a political compromise was achieved, or so it seems, which really showed the negative influence of Russia's membership, because there was no accountability at that point for Ukraine, or at least the only hope that I could see for accountability was that the European Court of Human Rights would come into play and do a role, perform its role there. So that point relates to Russia's bad faith and abuse of power. So my third final reflection, I'm sorry, and then I'll pass on to my co-authors, is this a matter of course, we blame Russia first and foremost of that. Is this a matter of the Council of Europe as an institution being a victim, and institutions of the Council of Europe, the court, being a victim? Lessons that I take from this study, personal reflections, are how the Commissioner for Human Rights, the court, the Parliamentary Assembly of the Council of Europe needs to be taken seriously by the states, who are the Council of Europe. So the states must support the Council of Europe politically and financially. Russia may have been able to exert its clout in the mid-2010s because of the financial state of the Council of Europe, threatening to withdraw its funding. Well, if states filled that funding gap, would Russia have had that leverage? The court has been woefully under-resourced and overburdened with work for far too long. And of course, politicians must support the court in their narrative and what they say about the court. These wouldn't be miracle solutions being able to stop what happened in relation to Ukraine, but they would make the institutions of the Council of Europe stronger, not weaker, and they would increase the chance of success, not reduce it, in relation to the matters that we're seeing today. Thank you very much.
Thank you, Ed. So my next question is for you, Konstantin, and it's reflecting on what Deputy Secretary General Berg told us in your remarks about how swiftly the Council of Europe responded to expel Russia in the immediate aftermath of the invasion of Ukraine. That was an unprecedented move. But was it the right thing to do legally, politically? What are your thoughts on that?
Thanks very much. First of all, thank you for giving me the floor and for inviting me to Dublin. I'm always happy to be back to Ireland. And despite my quite unpronounceable surname, which you did absolutely fantastically, I have to say, I am academically Irish. And yes, a couple of years ago, I even represented, was at the panel of Irish diaspora in British academia. So I am a part of Irish, and this is not a joke. Now, I was told by Andrew to speak for 5 minutes and then stop. And I'm sure that this is only because I did my PhD in UCD, not in DCU. So I will try to be as concise as possible, answering to this very complex question that you answered. And I only can refer to the book, like there are 2 chapters effectively answering this specific question of what was happening basically during a couple of months after the full-scale invasion of Russia. So basically, I will restrict myself to just a couple of legal, political points. First of all, yeah, I can agree with you. This was truly unprecedented from so many different levels. The Council of Europe is a fantastic organization. I love it. I dedicated my life researching it. But this is the organization which is not known for its speedy reactions to things. This particular reaction was very quick. And the very right so, because what else can be a significant violation of the statute of the Council of Europe if not a clear invasion of another member state of the Council of Europe? So this is probably the clearest example of a violation of Article 3 of the statute of the Council of Europe. Now, and this was unprecedented because this was for the first time a member state of the Council of Europe was expelled from the Council of Europe. In the 60s, Greece left, but Greece was allowed to withdraw from the Council of Europe, and then 4 years later, it came back. There were attempts to start a procedure, Article 8 of the statute procedure in relation to Turkey, which never went anywhere. So basically, a short answer, yes, this was a completely unprecedented event. The problem is with this expulsion, and this was clearly expulsion despite a very diplomatic formulation that the Committee of Ministers used, that Russia ceased it was excluded, or from the Council of Europe. It was clearly an expulsion. The legal problem was that basically the Article 8 of the Statute of the Council of Europe prescribes a very specific procedure for that. And unfortunately, from a very formal point of view, this procedure was not followed by the step-by-step. So I'm not going to go into major details on that, but I will give you a very quick assumption, a quick summary of what happened. So basically, according to this statute, you first need to suspend the country, which was done. Then you need to invite this country to withdraw, which was not done. And if the country doesn't withdraw, then expel. So basically, for a good reason, the Committee of Ministers skipped the second step, which is a departure from the procedure which is stated in the Statute of the Council of Europe. This procedure is problematic. I think that what Andrew is going to talk about, like maybe there are good reasons to change this procedure, but for the organization which is based on the rule of law, the procedures need to be followed. So I think that despite the fact that legitimately it was an absolutely correct decision, it was really a major violation of the core principles of the Council of Europe committed by Russia. If not this, what would be the good reason to expel a country? And I argued in my previous writing that like the Council of Europe should not be afraid of expelling countries which are not following the principles and values that are enshrined in the statutes of the Council of Europe. But it's important that it's done in accordance with the procedure that was agreed by the states. So it is a complex matter. We spent probably a bigger part of one of the chapters discussing this particular issue. So I would like to invite you to read and to discuss and to disagree with us. We disagree a lot among ourselves. You cannot imagine how much pain it was to adjust my correct position to what this gentleman had to say, but it was an incredible honor and privilege to write this book together. Thank you very much.
Thank you, Konstantin. So, Andrew, both Ed and Konstantin have raised some really interesting issues there and pointed to some questions that really need more thinking and more discussion. So what do you think are the key lessons that we can draw from this whole experience?
Thanks, and thanks for the privilege to have this session to talk about the content of the book. This was a cataclysmic event. Let's be clear. This was a turning point for the whole European and probably international human rights architecture. And we've seen, sadly, that it has just deteriorated as time has gone on since then. The Council of Europe, from the point of the decision to begin the process of expulsion, shifted its focus from one that had a very clear human rights, democracy, rule of law mandate, with a very cautious, conservative approach to how it engages with issues of conflict, to it recentering conflict to the very heart of what the Council of Europe does and will do from this point on. So that's really important, that we understand just how profound the moment is for the Council of Europe and Europe's human rights architecture. An unprecedented situation that a member state of the Council of Europe would invade another member state. But let's remember again, this didn't start 3 years ago. This started 11 years ago. This started when we had the little green men in the Donbass, and when we had the so-called referendum in Crimea, and we had a tacit acceptance of annexation by the international community. Okay, so why are we so surprised then that that was brought to its logical conclusion? Very profound political questions to be asked there, I think. But coming back to your question specifically, Tanya, to me, it's really important that if we are, and this, let's be clear about this also, we are very strong proponents of the Council of Europe. The objective of this book is to strengthen the Council of Europe. But to strengthen the Council of Europe, we need to be honest in our critical appraisal of what happened. Ed and Kostya both said that, you know, it was Russia's political leadership that decided to invade Russia, a sovereign, independent territory. And to do it on genocidal pretexts, by the way, denying the Ukrainians of the right to exist, etc., etc. But there were also other failures within the system that I think we need to look at. We describe a triple fault in the book, a triple fault. That is not to say a triple fault for invasion, but 3 layers of problems that, that need to be looked at. The first is Russia's decision to invade. Leave that to someone's side. The second is a more political failure, and that is the failure of the Committee of Ministers, either through inability or unwillingness to engage with very obvious transgressions and progressive deterioration of Russia inside the Council of Europe over many, 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 many years. Objectively verifiable, observable transgressions. Crimea is the pinnacle of this problem. And sadly, the reaction of the Committee of Ministers to the annexation, illegal annexation of Crimea, went little beyond declaratory and has gone little beyond declaratory ever since. That is a profound problem that we need to look at. And the third layer of challenge that I think we can draw as a lesson from this is also the system of the Council of Europe. And I need to be careful here as also a former civil servant of the Council of Europe who understands how the system works within, and that it is beholden and reliant on political will and good faith. But the system failed also. And what I mean by the system is we have monitoring mechanisms like the Commissioner for Human Rights, like the Framework Convention, like the CPT. We have other expert groups like the Venice Commission and so on and so forth, not to talk about the Court of Human Rights. All of whom did their jobs diligently in monitoring and reporting on the situation of human rights, democracy, and rule of law in Russia. This could be traced scientifically of repeated recommendations over years and years and years on exactly the same issue and no follow-up. The system failed. The system failed, okay? Why it failed is a different issue, but the system failed. And we need to think about how do we make this system, this virtuous cycle of monitoring, standard setting, monitoring and cooperation, how do we make that more effective? And I argue, and we argue, is that it's more than just political will. There's also a normative aspect to this. There's also an agency on the part of the Council of Europe mechanisms to be more animated and more decisive, to bring to the attention of the Secretary General that, you know what, maybe the fact that the former Commissioner for Human Rights was effectively persona non grata in Russia, that actually deserves a bit more than just being accepted as is. That perhaps there's a need for something specific on this. One of the points of disagreement between myself and Kostya and Ed, we had fantastic debates on this. I mean, really, you can't imagine. But there is an enormous spectrum of activity that goes from doing nothing to expelling. A huge spectrum. The trouble that we see is that spectrum is not exercised sufficiently well. That we don't see the willingness or the ability of the Committee of Ministers to engage in follow-up. So, okay, to conclude my point, I think our reflections are one thing. But from my perspective, if we're going to really draw lessons from this, there is a need for an inquiry of some sort within the Council of Europe. For the Council of Europe to look at itself in the mirror and see, well, what happened? What could have been done differently? Where were the opportunities that were missed? And this is not a reflective self-gratification exercise. This is about looking forward. How can we take steps now to build the Council of Europe for the future?
Thank you, Andrew. Okay, so I'll open it up to the floor. Is there anybody in the room who might like to ask a question? Yep. Gang, we might donate 2 of our microphones there. Yes, we have a microphone on its way to you, sir.
Hi, thank you so much. I was just wondering about the Russia's involvement with the Council of Europe, just on with it being expelled. I was just wondering if Russia is expelled from the Council of Europe, would that not, like since it was, would that not remove them from the dialogue? And do you think that was the right decision? Because if Russia was a part of the is essentially just removed from the dialogue and expelled after doing nothing, how are they supposing to like peace build essentially? Sorry, I don't know too much about the situation, but I was just hoping to get some more enlightenment. Thank you.
Maybe is this? Is it on now? Okay, all right. Maybe I'll just jump in there. Look, you're pointing to a key debate around this idea of, is it better in or out? Is it better to have a belligerent party at the table or to have them outside the door? And I think when it comes to when it gets to a point of an invasion, there is no question in our mind that the expulsion was required when it happened. The question, though, is probably more relevant for the 26 years before that, or at least since 2008 Georgia, 2014 Crimea, and so on. And was it the right thing to do? We can look at this now with the benefit of hindsight, and we can say, maybe no. But in actual fact, at that time, with the information that was available at the time, there were strong arguments to say that, look, let's hope diplomacy prevails. Let's hope engagement prevails. There were some signs early on, but that clearly took a turn from 2008 onwards. So, it comes to the better in than out. I'll pass to Kostya.
Thanks very much. Excellent question. Again, that has been discussed by us. And I know that in Strasbourg, there is still an argument that Russia should have been kept suspended for as long as possible. Well, I don't think that it would have any positive impact on anything, really. Like, Russia would likely to withdraw anyways, and this cannot be stopped. Although even if they didn't, I don't think that they would feel obliged to be under any form of pressure. So basically, if you have a state that is just there and is not collaborating at all with the organization, I don't think that there is any point in keeping this state as a member state only for the sake of, I don't know, a very important rights of people to apply to the European Court of Human Rights and that getting some compensation. I don't think that it's a very complex balancing exercise, but I think that at some point the balance is tilting so much to the side of expulsion that it becomes a political necessity to do so. So I think that legitimately the decision to expel after the full-scale invasion was absolutely correct from the practical point of view. So that would be my reflection on that.
Thanks. And of course, I agree. We probably disagree on aspects of it, but there's probably no single correct answer to what are essentially political matters. One could ask, and I think it's been said, would the Council of Europe had any credibility left if it didn't expel Russia in the light of what occurred? But here's the dilemma. I would put it this, personal opinion, the Russian government deserved to be expelled from the Council of Europe. The Russian people didn't deserve to be, in my opinion, expelled from the Council of Europe. This is the problem, isn't it? States sign human rights treaties. States are members of these organizations, and they are represented by governments who undertake to secure their human rights, but then don't. And then the problem is, what do you do about it when they don't? And the victims, you might say, some would argue, of Russia's expulsion are the people within Russia deprived of the opportunity to access the court. I can also understand, amongst others, I can also understand why expulsion has to be a last resort on the basis of, well, in the context here, of Europe becoming, in effect, a vacuum of accountability for Russia rather than the residual jurisdiction, etc. So it has to be a last resort then, because expulsion, going to your question, sort of ends hope of dialogue, or so it seems. But equally, there's that political question, isn't it? At what point is more harm being done to the organisation overall than good? So many layers to that then, sort of we go around in circles. But there's a complete dilemma, isn't there, of better in than out. And I'm still not sure where I stand on the matter, other than I do understand, of course, Russia had to be expelled in the light of what occurred. But so many issues then arise further.
Charlie, we have another question here from the front.
Yes, thank you. Jörg Polakiewicz, I'm from the Council of Europe, and I just felt provoked by Konstantin, but he knows what I would say. Because I was personally involved in these discussions about the relationship Article 7 and 8 of the statute, and just for the benefit also for the audience to give the opposite view. With all indulgence, I fully accept that the statute is a very obscure legal instrument dating back from 1949, and in particular, these provisions had never been applied before because Greece, where it was about to be applied, withdrew precisely before the Committee of Ministers took action under Article 8. But exactly for this reason, to be very brief, it was so important, in my view, that the Committee of Ministers in the Russian case draw the lessons and immediately triggered Article 8. And then if you follow Konstantin's interpretation, which is arguable, but then you would give the state that has already suspended basically the right to withdraw on its own terms, because it could choose the withdrawal, the modalities, and this was what in the Committee of Ministers was in the end not accepted on the basis also of the rules of procedure. But to give to a very simple analogy of a tennis club, if you compare membership of the Council of Europe with membership in a tennis club, you may at any moment decide to leave, but you must comply with the applicable notice periods. But if you set the clubhouse on fire, you will be immediately suspended and your membership terminated. This was the view that prevailed, at least in the Committee of Ministers. But I really look forward to you reading your book, and I think it is a very, very valuable contribution, and particular about the lessons learned that you and Andrew and Ed mentioned. So thank you very much and looking forward to more engagements. Thank you.
If I can, thank you very much, Jörg. I read about your tennis court metaphor already, and I thought long and hard about that. We discussed it as well. Actually, this is technically such a minor issue, which is included in the statute, and I think we checked at Havo also. It didn't give us much of a explanation of how exactly this procedure should be applied. Myself and my colleague Vasilis Tsivelekas, we wrote the whole 20,000 words paper specifically on whether the act was valid from the international law point of view or not, and we come to the conclusion that despite this procedural impropriety, the final act of the Council of Europe to expel Russia was valid from the point of view of international law. But obviously, I don't have time to recite 20,000 words of our very complex and long legal explanation. I'll pass to Andrew. I think he wants to say something.
Just one point to add on this, and Jörg, I think you actually probably made the point implicitly. The statute is of a different time, and it's a statute that no longer reflects practice. I think the very fact that we got to a point where the committee ministers, in my view, legitimately went directly for the expulsion option. I like this tennis courts analogy. That creates a statutory problem because the practice now has overtaken what the statute says. So to my mind, we need to revisit this question of, is the statute any longer fit for purpose? That is one provision, but there's another provision that I think is incompatible with the the direction of travel of the Council of Europe right now. And that is Article 8D around the defence clause, this statutory defence clause. Is it 8D? Anyway, no, it's not 8D. You can correct me. Anyway, the defence clause, which essentially says that the Council of Europe has no mandate in matters of national defence. I think there's an ambiguity there. So I think the question of the statute is one that needs to be looked at much more closely and holistically.
Just one word. I'm sorry. I know that Ed is like it's Ed's turn, and I think like I wanted just to agree with Andrew that there should be some really reflection on the part of the Council of Europe, both legal and political, and not only in relation to Russia's expulsion, but in relation to everything that is happening now, like, because we are living in a completely different political universe at the moment, and continuing business as usual is not an option anymore. And like this inquiry might be a good idea to actually see creatively, but not overly creative. Like I have problems with creativity these days. You know, creatively looking into how to react to the reality.
Thanks. Very briefly. Yeah, I think Article 8 reflects the era in which, agreeing with what Andrew was saying, the statute was drawn up. It wasn't expected that states would invade other states when Article 8 was drawn up, I'm sure. So this scenario was not envisaged, hence the invitation to withdraw material can be seen in that light. I like the tennis club analogy. I was thinking of red cards and yellow cards in football, but anyway, end that. But my final reflection is, well, one thing the Committee of Ministers might have done is invite Russia to withdraw with immediate effect. Then it would have presumably covered that point as well. I can't remember if we discussed that in the book. It's so long since we wrote it, but maybe that was one workaround. But
Okay, so we have a number of people questioning. So I'm going to we've got 7 minutes left. So I'm going to bunch 2 questions together, if that's okay. This gentleman here at the back and this gentleman in the red jumper are the next 2 people that I noticed. So we'll be brief, quick and insightful, and so will you guys.
Thanks very much, Rohan Radia from the British MC. Very insightful. It's always difficult answering counterfactuals, but Andrew, you mentioned the full spectrum of actions the Council of Europe could have taken since the 90s, between kind of doing nothing and keeping Russia as it was and expulsion. Would any of that have changed Russian behavior? And essentially, I mean, if the answer is no, it wouldn't have changed Russian behavior. To be frank and cynical, what's the point? What's the point in having the Council of Europe there? In this sense, obviously there are other good functions, but in this sense, what's the point if Russian behavior wouldn't have changed?
Thank you very much. Congratulations to the panel for their presentations this morning. Colin Rafter, I'm formerly in the Department of Foreign Affairs. I'd be brief and blunt. If you had your way, how would the panel give real muscle to the Council of Europe in terms of possible future actions? Thank you.
Okay, so we can actually work those 2 quite nicely together. That's turned out well. All right, chaps, who wants to go first?
Will I go because I have it in my hand and the first question was directed to me? Thank you for the question. I think it's helpful. I think that so let's be clear what the spectrum could look like. The spectrum could have looked like the withdrawal of voting rights. It could have looked like specific debates at the Committee of Ministers around a particular issue. It could have looked like a regular repeated item on the agenda. There are several of them, as far as we know, on the Committee of Ministers agenda for many, many years, which are seem to be kind of pointless, but you know what? They kind of get the hairs up on the back of the necks of the delegations that are dealing with that issue. So I don't accept the premise that pursuing any of these would be pointless or have no effect. I think, to bring it to its logical conclusion, the political leadership, the current political leadership of the Russian Federation looks to me like from 2014, at least, they were on a very clear path, that they were not going to stop until they got their way, their perceived way. But as I say, that does not mean that the Council of Europe or any intergovernmental or international law framework should just sit back and say, well, sure, look, if it's not going to work, what's the point in bothering even trying? In fact, the opposite should be true. The exact opposite. We should be the Council of Europe should have been energized even more to do what it can, at least putting up in lights and making it plain to see the direction of travel. So that's my view on that. How to reinforce, just while I have the microphone. There's two very obvious ones for me, Colin. The first one is resourcing. The Council of Europe has a paltry budget. It is scandalous in this day and age that the Council of Europe is operating on the budget it's operating on. And I'm not going to talk about any specific institutions within it, but generally, and we can go specific separately, but that's one aspect. The second thing is, and to me, it's equally difficult to comprehend that we have only had 4 heads of states and government meetings of the Council of Europe member states in the last, whatever it is, 20-ish years more. No, what am I saying? How many? Yeah, ever really in the history of the Council of Europe. When you look at other intergovernmental organizations where the heads of state meet 4 times per year, I think that is an issue that could be immediately remedied. It does matter. It gives political energy, political impetus. It's a catalyst for reform. It's also an opportunity for politicians at the correct level to understand where the rubber hits the road with this stuff. I remember when I worked for the Council of Europe, it's my last point, I will hand the microphone over. I remember when I worked for the Council of Europe and I had the pleasure of following the work of the committee ministers very closely. And a diplomat said to me in the margins, he said, you know, Andrew, really, the Council of Europe doesn't matter until it matters. The Council of Europe doesn't matter until it matters. What he meant was, until we're held up in lights as being the bad student, that's when it matters. We need to really try to work on changing that, lead to be a little bit more self-assured, and get more heads of states meetings, I would say at least once per SG mandate.
I don't really agree with that, but we can discuss that further. Answering your question is the Council of Europe matters, right? I think it does, and I hope it does. What I can reverse the question to you. So, like, if nothing could change what is going on in Russia, why bother at all? Why would we need international law at all? Like, it is very difficult to talk in hypotheticals in these circumstances. What would happen if the European Court of Human Rights, and I'm sorry, Shifra, I'm not pointing at you, like, if the European Court of Human Rights was quicker in delivering some key political judgments, very good judgment, very robust, like finding multiple violations, but not 10 years later, but 2 years later, like 3 years later, etc. What would happen? It is very difficult to talk in these hypotheticals. Maybe you can also throw it back to me saying, like, but maybe nothing would happen. They would ignore this judgment as well as some other judgments. But it doesn't mean that we should be complacent and say that, like, okay, nothing works, let's go home. That's it. I don't think that it's a good position. Talking about, again, a hypothetical question, what would give the Council of Europe more bites? I'm not so sure that actually meetings of heads of states would make such a major difference, but like Andrew is more a practitioner than I am. But do you want me to go, skies thinking or realistic one? Well, if you want me to go like, give the Council of Europe the ability to fine states, like the ability to apply effective economic sanctions like some other international organizations can do. Provide more, direct influence on the Council of Europe on the ground. But we are hitting another problem, the sovereignty problem. Like the capitals might not be very thrilled about, bureaucrats from Strasbourg coming to them and telling them directly what to do. So, like, basically, if you want the Council of Europe to be very effective, give them direct instruments to affect the situation on the ground. But how politically realistic and possible that is, this is a very, very open question. I'll pass to Ed.
2 points. Firstly, the Council of Europe, I guess, can only work in relation to states that want to remain within it. Ultimately, Russia didn't. But a long game may be relevant there, maybe not in Russia's case, but my impression is things are changing in relation to Poland, for example, with general political change there. So that's one point. The second point is why, what's the point, so to speak? The Council of Europe stands for European values of effective political democracy, human rights protection, and the rule of law. In relation even to the court and the judgment it delivered a couple of weeks ago, that was seen in relation to restrictions on freedom of expression, prosecutions of people in Russia, residual jurisdiction for condemning the war. Europe stands for that. It'll be seen again, perhaps, I hope, in relation to the interstate cases. Of course, this will have to be through the lens of the convention, the limitations of that, but those judgments, I hope and suspect, will be a record of historical truth, fact in relation to what's occurred through the lens of the convention. And if we look at an earlier judgment of the court in relation to this, the court uses the expression, the European public order is at play here. And I see it through that lens. That's what Europe stands for. And that's profound, in my opinion, even though it doesn't always get the results we want. Thank you.
Okay, so I'm really sorry. I know there are loads of more questions, but we have come to the end of our allotted time. And, you know, in the spirit of the Delhi Institute, we've got some great food for thought there. And so I'd like to congratulate the gentleman on this amazing book. I'm really looking forward to reading it. We also have food for tummies through that door, and to the left there's tea, coffee and cakes. Restrooms can be found through this door to the right, and I would just like to finish in the traditional way by thanking Ed, Constantine and Andrew for a wonderful, thought-provoking conversation.
Okay, ladies and gentlemen, we might reconvene if you don't mind, just with conscious of the time. Hope you're all sufficiently caffeinated and enjoyed some of the nice cakes. Now we're going to move on to another excellent segment of the day. We're moving, I suppose, from the broad political, geopolitical, institutional situation to the more judicial aspects of the question of accountability. And it's my really enormous pleasure that we have the former president of the European Court of Human Rights, Professor Siofra O'Leary, with us to address the conference now. Siofra doesn't really require an introduction, but I'm going to give her an introduction nevertheless. Siofra was a former judge and president of the European Court of Human Rights from 2015 until 2024, so just last year. She was elected as a judge in respect of Ireland in 2015, and since 2020 she served as the president of Section 5, vice president and the court's 17th president. And she was, importantly, the very first woman to have performed this role in the court's history, which is an incredible accolade in itself. Prior to joining the European Court of Human Rights, Siofra worked for about 2 decades at the European Court of Justice of the European Union, both in judicial and in administrative capacities. Siofra is an accomplished author and academic, holding visiting professorships at the College of Europe in Bruges, and she's a full adjunct professorship at the University College Dublin. In 2024, UCD conferred on her the Ulysses Medal in recognition of her legal work and European service. And she's also received an LLD honoris causa from the University of Edinburgh. And with that, it's my great pleasure to invite Siofra to address the conference.
Thank you very much, Dr. Ford, Andrew, members of DCU, ladies and gentlemen here in Dublin and abroad. It's a real pleasure to be back in DCU, and my warm thanks to all of the organisers. Since I was last here in October 2022, the world has become a noisier, and I think we can all say, a more dangerous place. Confronted with the horror of the brutal conflict in the Middle East, I think it was easy to forget the slow war of attrition being fought to the east in Kharkiv, Kherson and Zaporizhia. The Middle East conflict also brought out into the open how precarious respect for the work and authority of international courts can be when it doesn't fit the national, political, or, let's be honest, the economic agendas of certain leaders or certain states. I'm very grateful to you, Andrew, for giving the European Court of Human Rights a seat at this conference table. And I'd like to also extend a heartfelt thanks to Professor Bates and the members of the previous panel. As you've just heard, I served at the court from 2015 to 2024. People talk about we live in turbulent times. It was really turbulent. The war didn't start in 2022. Aggression didn't enter into the new European modern history in 2022. It started in 2008 in the conflict between Georgia and Russia. And regarding what Professor Bates said and the lessons to be learned, whether there is an inquiry or not, it's not actually rocket science. If you want quality justice, national and international, you have to fund it, you have to provide the necessary resources, but then also you have to stand by politically and legally and accept your own accountability, and not just, for example, hail an interim measure in relation to the Russian Federation, but undermine the interim measure procedures if an interim measure is handed down in relation to your own state. So there are lessons to be learned, but actually we know a lot of the answers to those lessons already. Since one of the focuses today will be on the possible establishment of a special tribunal, it strikes me as both useful but also very necessary that decision makers and the public are aware of the work already done by the European Court of Human Rights and of other work still pending in relation to the conflict in Ukraine. The Deputy Secretary General mentioned the heads of state and government, and as I repeatedly reminded the heads of state in the run-up to the 4th Council of Europe Summit in Reykjavik, the European Court of Human Rights was then, and it remains today, the only international court examining at an advanced merits stage legal claims relating to the conflict in Ukraine. When the summit took place, Russia had been expelled from the Council of Europe 3 months previously, but it did remain a high contracting party to the convention until September 2022, which was of course key. The continued accountability of Russia as a respondent state, having been a former high contracting party, was at the heart of the court's memorandum in advance of the Reykjavik summit, and it was of course at the heart of the summit resolution and the appendix devoted to the work of the court. I'm moving the microphone because I realize in your new building, this podium is either for small people or people with very good eyesight. Turning first to the role of the 75-year-old convention in cases of conflict, particularly those within the territorial jurisdiction of Council of Europe member states, I think it is very important to keep in mind both the size of the Strasbourg Court's docket and what type of cases that docket is composed. According to the 2024 statistics published in January, there are approximately 60,000 applications pending before the Strasbourg Court. 13 of those pending cases are interstate cases introduced pursuant to Article 33. And of those pending interstate cases, 11 are conflict cases. 3 relate to the continuing conflict in Ukraine. A 4th case concerning the invasion of Crimea in 2014 was decided in June 2024, and that's a judgment to which I'll return during the course of my intervention. In relation to the Ukrainian conflict, as the Deputy Secretary General mentioned, there are thousands of individual applications before the court which relate to events in Crimea, eastern Ukraine, the Sea of Azov, and the military operations of the Russian Federation on the territory of Ukraine since the 24th of February 3 years ago. But as the court did in relation to the interstate cases lodged by Georgia following the conflict with Russia in 2008, it has proceeded to deal first with the interstate cases and will move on to the individual applications once those interstate cases have been resolved. This is because certain factual questions, but also crucial legal questions in relation, for example, to Article 1 jurisdiction, will have been resolved in the interstate judgments. The main case, which is still pending, Ukraine and the Netherlands against Russia, concerns 3 applications spanning events in eastern Ukraine in 2014, the downing of Malaysia Airlines flight MH17 in July that year, and the 2022 invasion. It's very important for me, before outlining the role of the court and the limits thereto, to emphasize that I remain a member of the composition in that case, and therefore I will take no position on any legal question which arises therein. Like any judge, it is my duty to display neither fear nor favour, and so I proceed on the basis in those pending cases of allegations, whereas other speakers may refer to them in other terms. As regards the role of the court, particularly in interstate conflict cases, an excellent overview was provided in the admissibility decision in relation to the Ukrainian and Dutch applications handed down in January 2023, referring to the interstate decisions and judgments of the court dating all the way back to a judgment which I'm sure you are familiar with, Ireland against the United Kingdom. The court explains in terms very reminiscent of Professor Bates the following, and I quote, "The purpose of the high contracting parties in concluding the convention was not to concede to each other reciprocal rights and obligations in pursuance of their own national interests, but to realise the aims and ideals of the Council of Europe as expressed in its statute, and to establish a common public order of the free democracies of Europe with the object of safeguarding their common heritage of political traditions, ideals, freedom, and the rule of law." Given the declarations made recently at the Munich Security Conference, let's not forget the examples of individual and interstate cases which have rendered concrete for over 70 years these crucial but abstract aims. It's not for me, as a former judge or court president, to trespass into politics, but I think I can say that political arrogance has never been an attractive characteristic. Political ignorance or misrepresentation of facts is absolutely unforgivable. According to established Article 33 case law, there are two basic categories of interstate application. The first category concerns cases raising general issues brought with a view to protecting the public order of Europe. The second category covers cases where the applicant state complains of violations of the basic human rights of one or more identifiable persons or groups of persons. In the Crimea admissibility decision, the court rightly, in my view, nuanced this previous distinction by adding that this second category of interstate case also contributes to the protection of the public order of Europe. Although the case law of the court has developed certain special characteristics or exceptions in interstate proceedings in relation, for example, to administrative practices, which I'll come to in a moment, the court's methodology when it comes to examination of the Convention's substantive provisions is similar whether it is dealing with an interstate or an individual application. It is useful to remember that allegations of genocide, war crimes, or the crime of aggression are generally made in interstate conflict cases. But while these allegations provide the backdrop to an applicant state's allegations, the court is not competent to resolve such legal claims, and it must restrict itself to the legal issues arising under the Convention itself. Evidentiary rules may differ in interstate cases, and as I'll explain a little bit later, but this is because of the nature of conflict cases and interstate cases generally. Respondent states in these cases may be the only ones in full knowledge of the facts in relation to which different violations are alleged. As regards the existence of an administrative practice, and this plays a key role in interstate cases, the meaning of this concept was established by the former European Commission on Human Rights in the early interstate cases. An administrative practice comprises of two elements: the repetition of acts and official tolerance. The rule on exhaustion of domestic remedies, which, as you know, is a key principle underlining the Convention mechanism, doesn't apply where an administrative practice has been shown to exist. The overarching limit to the role of the European Court of Human Rights and the Convention in these conflict cases lies in the nature of both. The Court of Human Rights is a regional human rights court whose jurisdiction relates to the interpretation and application of a regional human rights instrument. It does seek to interpret that instrument in harmony with other provisions of international law, but the court's role is not to enforce those other international instruments. In the remaining time available to me, I thought I would flag 5 factors which are determinative of how the court exercises the role assigned to it in interstate cases. Firstly, delimiting the scope of the complaints before it. In the court's admissibility decision in the Crimea case, One of the key limits to its role was flagged early on in the decision. The court stated, and I quote, "Having regard to the parties' submissions, the court considers that it is not called upon to decide in the abstract on the legality of the Russian Federation's purported invasion and occupation of Crimea, other than by reference to the rules contained in the Convention. Nor are the applicant government seeking a ruling from the court on the legality per se under international law of the annexation of Crimea and accordingly of its consequent legal status thereafter. Ukraine, as we well know, has made international law a centerpiece of its war effort since the full-scale Russian invasion in February 2022. But from the extract above and the court's reference in that part of the admissibility decision to decisions of the International Court of Justice and the arbitral tribunal established under ITLOS, it's clear that the Strasbourg Court and other international tribunals have paid careful attention to the scope of the complaints lodged before each one and to the limits of their respective jurisdiction. For the European Court of Human Rights, this means jurisdiction within the dual sense of judicial jurisdiction under Articles 19 and 32 and state jurisdiction within the meaning of Article 1. As regards the court's competence and jurisdiction under Articles 19 and 32, the court in the Crimea admissibility decision indicated that it was mindful that questions raised in such interstate conflicts cases inevitably have political aspects. However, it insisted that that fact alone does not suffice to deprive them of their character as legal questions. The second factor is jurisdiction within the meaning of Article 1. As you well know, Article 1 provides that the high contracting parties shall secure to everyone within their jurisdiction the rights and freedoms defined in Section 1 of the Convention. In interstate cases involving Georgia and Ukraine, the court has distinguished between the establishment of Article 1 jurisdiction as a preliminary issue, which it deals with, if possible, at the admissibility stage, and the issues of attribution and responsibility of the respondent state under the Convention for the acts complained of, the latter fall to be decided at the merits stage of proceedings. Jurisdiction was established in the Crimea admissibility decision, distinguishing the period prior to the 18th of March 2014, the date of the signing of the so-called Treaty of Unification, and the period thereafter. As regards the later period, the parties agreed that Russia was exercising jurisdiction, but the Russian Federation argued that from the 18th of March 2014, its jurisdiction was territorial. The court carefully plotted a path to a conclusion to the effect that for the purposes of the admissibility decision, it proceeded on the basis of the assumption that the jurisdiction of the respondent state over Crimea is in the form or nature of effective control over an area rather than in the form or nature of territorial jurisdiction. The question of jurisdiction in relation to parts of the applications in the Ukrainian and Dutch case remains pending and is far thornier. I'll outline the issues, as I said, without taking any position on their resolution. The difficulty in establishing extraterritorial jurisdiction under Article 1 arises in particular in relation to the active phase of hostilities in the context of an international armed conflict. In its judgment in Georgia, Russia 2, handed down in 2021, the court held, and I quote, "It attaches decisive weight to the fact that the very reality of armed confrontation and fighting between enemy military forces seeking to establish control over an area in a context of chaos not only means that there is no effective control over an area as indicated above, but also excludes any form of state, agent, authority and control over individuals." The court continued, "Having regard in particular to the large number of alleged victims and contested incidents, the magnitude of the evidence produced, the difficulty in establishing the relevant circumstances, and the fact that such situations are predominantly regulated by legal norms other than those of the Convention, specifically international humanitarian law or the law of armed conflict, the court considers that it is not in a position to develop its case law beyond the understanding of the notion of jurisdiction as established to date." Now, I should stress that the Grand Chamber, in which I didn't serve, was divided on the issue, 11-6 if my memory is correct, with trenchant criticism of the majority position expressed both in dissenting opinions and in some academic commentary. As regards the pending Ukraine and the Netherlands against Russia case, whether the respondent state has Article 1 jurisdiction in relation to multiple acts turns on whether or not the above restriction on the establishment of extraterritorial jurisdiction applies to the active phase of hostilities in Ukraine. In the November 2022 admissibility decision, the Grand Chamber decided to join this vital question to the merits. However, it did state in paragraph 558, and I'm referring to the paragraph so that you know that these are the words of the court in the decision and not the words of the former president. The court stated that the Georgia-Russia II judgment cannot be seen, and I quote, as authority for excluding entirely from a state's Article 1 jurisdiction a specific temporal phase of an international armed conflict. Of note, I think, in the pending case is the fact that 26 high contracting parties to the convention intervened in support of Ukraine's 2022 application. The court asked the parties and the intervening states in advance of the July 2024 hearing to engage in detail with this vital jurisdictional question, which was then at the heart of the oral hearing, and you can actually access the record of the oral hearing on the court's website. I should add that at this hearing, the Russian Federation did not participate. The Grand Chamber will speak in due course, and today, as you can understand, I will venture no further. Factor number 3 is compliance with the duty to cooperate. A recurring problem in interstate cases, even non-conflict ones, has been the failure of respondent governments to cooperate with the European Court of Human Rights. You will remember that the European Commission had expressed its, quote, frustration at the lack of assistance from the United Kingdom in the Ireland against the United Kingdom case, which led the court in 1978, and I quote, to regret this attitude. This soft tack on lack of cooperation is not reflected in the court's more recent jurisprudence in interstate cases. Since the expulsion of the Russian Federation from the Council of Europe, the respondent state has ceased to communicate or cooperate with the court. In the Crimea case, the court considered that the respondent government had failed to furnish all necessary facilities to the court in its task of establishing the facts of the case, and there had been an unexplained failure to submit requested material, and the respondent government's non-participation had had prejudicial effects on its examination of the case. It therefore found a violation of Article 38. A violation of Article 38 was also found in the second Georgian interstate case. It's worth noting that while the Russian Federation ceased, following its expulsion from the Council of Europe, to cooperate with the Court of Human Rights, it has continued to engage, at least in writing, with the International Court of Justice in the proceedings pending before it. Another example of the selective choice by states to engage or not engage with international judicial processes with which we should proceed. Lessons learned with great care in the future. The fourth factor relates to evidentiary challenges. The admissibility and merits judgments in interstate cases have dealt in detail with standard and burden of proof issues, and I would refer you to the decisions for the technical details. Georgia, Russia II and I and the Crimea case provide you with a very good guide in that respect. In the 2 Ukrainian admissibility decisions and 1 judgment to date, one gets a sense of the evidentiary burden and challenges which such cases pose for the parties, but also for the court. In the Crimea case, the applicant government emphasised the practical difficulties associated with gathering evidence in Crimea related to the denial of access of its officials and of independent monitors to Crimea. In addition, they argued that the Russian Federation was in exclusive possession of substantial evidence relating to the administrative practices complained of, and they also referred to the military attack by the respondent state that was unfolding at the time of the lodging of the application. These difficulties are alleged with even greater force by the same state in the pending Ukraine and the Netherlands against Russia case. For the court, the difficulties lie in both the dearth and volume of evidence submitted, in its varied nature, its varied prominence and probity, and in the fact that it comes in waves and not in one single batch. Entire registry teams have been established within the court to assist in the compilation and processing of evidence. And I take, of course, Constantine's point very well stated point regarding delay. For example, the Court of Human Rights took far too long to hand down the decision in eco defense. And one sees in the case of Novaya Gazeta, which was published recently, that speed is of the essence, and greater speed is possible. But if you deprive a court of resources, a deprivation which stemmed directly from the failure of the Russian Federation and also Turkey to contribute as they should have to the court's budget and that of the Council of Europe, the effect is palpable, and it even includes turning off the lights in the court and depriving all those who work within it of any heating. And Strasbourg gets quite cold in the winter. In Ukraine and the Netherlands against Russia, the applicant government relies on material from international organizations and bodies, such as the OHCHR and the OSCE and PACE, information from Ukrainian state and government agencies, witness statements, evidence collected in the context of domestic criminal investigations, reports by NGOs, research collective, newspapers, articles, videos, and information from other states. In the admissibility decision, the court detailed its approach to this different type of evidence coming from different sources. As regards the downing of flight MH17, they relied on the Dutch Safety Board report, the work of the Dutch-led joint investigation team, the reports by Bellingcat, as well as, crucially, the in absentia criminal proceedings concluded before the Dutch courts in 2022 in relation to those considered to have been the masterminds behind that tragic event. As the court explained in its Crimea judgment, it has to attach different weight to different types of evidence depending on where that evidence comes from. The court has emphasized in successive judgments in individual cases decided since the Russian expulsion that a refusal to cooperate cannot lead to the abandonment of pending cases. However, violations can only be established when the court is satisfied in fact and law to the requisite standard. My fifth and final factor relates to execution and crossover. It's fair to say that the execution of interstate cases is very complex. The Committee of Ministers remains seized of the execution of the judgment in Cyprus against Turkey, which was handed down in 2001, with the question of just satisfaction decided in 2014. The cases decided thus far in relation to the 2008 conflict in Georgia also remain the subject of Committee of Ministers supervision. As regards how the committee will proceed in relation to the Ukrainian cases, I think it best that I leave to the representatives of the Council of Europe to answer any detailed questions in that regard. But in the court's judgment on just satisfaction in Georgia against Russia II, decided in April 2023, it emphasized, and I quote, Article 46 requires that the Committee of Ministers sets forth an effective mechanism for the implementation of the court's judgments, also in cases against a state which has ceased to be a party to the Convention. Mr. Berg has explained the establishment and functioning of the Register of Damage, in relation to which court personnel provided their expertise prior to its establishment and subsequently. The register functions independently of the court's judgments, but those judgments, one imagines, will be useful for its work and that of a possible claims commission. The court's judgments will or should also be of relevance for the work of the ICC and the ICJ in the exercise of their own distinct jurisdiction in cases pending before them. In conclusion, ladies and gentlemen, the interstate work of the European Court of Human Rights is time-consuming, highly complex, and also vital. It's a reminder of the value of the Convention system, primarily as an instrument to prevent conflict by ensuring effectively functioning democratic states, the key words being effectively functioning. But also, the Convention is an instrument to respond to conflict in terms of remedies and justice. In the current political climate, and given our knowledge and experience of national and regional conflicts, including on this island, let us not forget how important justice is in terms of lasting peace and reconciliation. I thank you for your attention.
Thank you very much, Shifra, for that real tour de force. And I think what struck me as you were speaking was that one can probably imagine the European Court of Human Rights as being one of the key threads in this kind of tapestry of effectiveness. weaving its way through and having an influence in other courts and other processes, including, of course, what we're going to speak about now in a moment. As has been said, the Register of Damages for Ukraine was established as a key outcome of the Reykjavik Summit and the Reykjavik Declaration, and an enormous success for the Council of Europe. And discussions then have turned to the reparation phase and the Claims Commission. But another aspect of this, of course, is around the crime of aggression, and whether the crime of aggression can indeed itself be effectively dealt with, which leads us to a discussion on the establishment of a court with specific jurisdiction for the crime of aggression. And it's in that context, it's now my really great pleasure to invite my colleague and friend, Jörg Palakiewicz, who is the legal advisor and director at the Council of Europe, a director of legal advice and public international law. Jörg has extensive experience in the field of international law. He has been the legal director since 2013. Between 2010 and 2013, he was head of the Human Rights Development Department at the Council of Europe, overseeing intergovernmental cooperation work related to human rights, including reform of the European Court of Human Rights, accession by the European Union to the European Convention on Human Rights, and capacity building activities in Eastern and Central Europe. Jörg is well known to many of us. He's a very accomplished author and scholar and legal academic, and he's been instrumental, importantly, for this session. He's been instrumental from the Council of Europe's perspective to the core group on the establishment of the Special Tribunal for the Crime of Aggression within the framework of the Council of Europe. And with that, I give the floor to Jörg.
Thank you, dear Andrew, for these kind words. And it is indeed a great privilege and pleasure for me to be here with you in Dublin to speak on the topic of the Special Tribunal within the framework of the Council of Europe. And I note that we have a panel on the topic which will discuss the prospects, politics, and practicalities of such a tribunal. All this has, of course, as all of you are aware, become much more complex following the recent change of US policy. But I will just make a modest contribution as a lawyer, trying to set the stage for this panel by providing a summary of the developments regarding this process, and in particular, how the Council of Europe, how and why the Council of Europe became so relevant in this process. You are probably all aware that shortly after 2022 full-scale invasion began, there were calls for such a special tribunal, and a group of states dedicated to achieving justice for Ukraine began discussing how such a tribunal could be created. This so-called core group is now some 40 states strong, mainly comprising the members of the Council of Europe and the G7, including up to this day the United States of America, Australia, Costa Rica, and Guatemala. The core group is composed of legal advisors from the relevant ministries of participating states, as well as from the legal services of the Council of Europe, the European External Action Service, and the Commission, European Commission. I had the really privilege to work with some of the finest legal minds out there for the last 2 years, representing the Council of Europe. This was a truly extraordinary voyage. We worked closely, particularly closely, with the colleagues from the EU Legal Service and, of course, the Ukrainian team, which was led by Anton Konovich, who has become a real friend and whose resilience and determination I deeply admire. Creating a special tribunal for a crime that has never been prosecuted since Nuremberg and Tokyo is not a small task. In the core group, we were guided by the concern to fill the accountability gap that deplorably exists for this crime, without, and I should stress this, without undermining the significant progress that the international community has collectively achieved, in particular through the International Criminal Court. Indeed, complementarity with the ICC procedures was and is a guiding principle throughout our work and is fully reflected in the legal instruments that we have prepared. The core group had to address many difficult issues as to how such a tribunal would look like, the law it would apply, the application of immunities, and similarly complex issues which have strong political connotations. The group over the 2 years has made important progress and is fine-tuning the precise configuration of all these matters. In fact, fully drafted legal instruments have been prepared and the final text is within reach, at least I should stress at technical level. Only yesterday, before coming to Dublin, I was chairing a video conference with the core group in order to prepare the next meeting of the group, which will be held in Strasbourg in mid-March. But let me first come to the role of the Council of Europe. How has this developed? In fact, there has been quite a tremendous development. When you read the Reykjavik Declaration, which was already referred to by previous speakers, you will find just a very benign, small mention that the Council of Europe should participate as appropriate in relevant consultations and negotiations and provide concrete expert and technical support to the process. In Reykjavik, the focus was very much on the Register for Damage, which was indeed created and established just in parallel. However, it's quite an amazing process that the Council of Europe evolved. The role of the Council of Europe evolved from providing merely support to present the most, some say the only realistic option for such a tribunal. And I'm very proud that with my small team, we became pen holders of the process. Of course, a lot has to do with the paralysis of the United Nations, so that the Council of Europe had to come into this process. Indeed, the core group began early last year to consider a new model for such a tribunal, the so-called Council of Europe model, which would consist of 3 basic documents. First of all, a bilateral agreement between Ukraine and the Council of Europe, to which the statute of the tribunal would be annexed, which will outline all the procedures and the composition of the tribunal. A separate enlarged partial agreement would establish a management committee responsible for financing the tribunal and assisting in other administrative and managerial aspects of its operation. This enlarged partial agreement has become a very popular instrument and was successfully used for creating the Register of Damage. It allows to associate non-member states on equal footing to the work within the Council of Europe. And it's very important, I think it was mentioned by the Ukrainian ambassador, already in April 2024, the Committee of Ministers also gave formal backing to the representation of the Council of Europe in the core group by adopting a series of decisions. It's also not unusual in international criminal law that the ad hoc tribunals have been created through bilateral agreements with international organizations. This was done for Sierra Leone, Lebanon, the Extraordinary African Chambers, and very recently for the Gambia. So you can argue, why should it not be possible for Europe? It is true that none of these, I should however stress that none of these examples concerned the crime of aggression. The advantage of the Council of Europe to assist in the establishment comes also from the fact that such a procedure would anchor the tribunal within an existing institution. It could thus draw on the Council's institutional infrastructure and know-how to support both the negotiation and operational phases of the tribunal. In fact, we have the example of a very well-functioning international tribunal inside the framework of the Council of Europe, the European Court of Human Rights. And the Council of Europe also brings the essential dimension of legitimacy. We know that the tribunal's perception by the international community, defendants and victims of the crime will be key to the tribunal's success. This legitimacy is strengthened by the Council of Europe's commitment to promoting and upholding internationally recognized human rights, and also, very importantly, involving civil society. The fact that both the affected and the aggressor state were members of the organization at the time of when the aggression commenced has also important implications for legitimacy. Let me say a few words, but I have to be relatively succinct on the substantive issues that were particularly contested. These were basically 4: immunities, jurisdiction, trials in absentia, and the definition of the crime of aggression. What is very important that on these issues, the last meeting of the core group, which was held in Brussels in February, the core group identified a kind of package deal, a compromise covering all 4 issues. And we hope to finalize and consolidate this compromise, this deal, at the forthcoming meeting in Strasbourg. The texts are unfortunately still confidential, but I was therefore only mentioned 2 quite key issues in my view. First, under the Council of Europe option, the Special Tribunal would be established under the auspices of the Council of Europe, and can thus be described through an international agreement between Ukraine and the Council of Europe, and can thus be described as international in form. Its jurisdiction would, however, be firmly rooted in Ukraine's uncontested territorial jurisdiction over the crime of aggression. In fact, the Ukraine Criminal Code contains a definition which is based on the Nuremberg definition, very similar to the definition contained, by the way, in the Russian Federation's criminal code. The tribunal would thus internationalize prosecutions that have already been started by Ukrainian prosecutors, and also some other countries collaborating in the framework of the International Center for the Prosecution of the Crime of Aggression, the ICPA, which was created under Eurojust in The Hague. The second point I wanted to mention on immunities, there is consensus, and I think this is also very important for the development of international law, that alleged perpetrators will not be able to hide behind functional immunities. Investigations will be launched against the leadership of the Russian Federation, possibly also Belarus, and indictments prepared. Functional immunity must, however, be distinguished from personal immunity of the so-called troika, the head of state, head of government, and foreign minister. As long as these persons hold office, their immunity has not been waived. The Council of Europe is not the Security Council. We cannot pierce the veil of personal immunity, which is a foundational principle of international law. Today, this brings me to the conclusion. Today is the 1099th day of Russia's aggression against Ukraine. At last year's, I must stress not this year, but last year's Munich Security Conference, the then Estonian Prime Minister Kaja Kallas said, and I quote, "This is the European hour and we need to rise to the challenge. It's on us. To defeat Russia, we need to think out of the box. That is what Russia is really afraid of." And I think this is what the core group has done. We have thought out of the box. We have created a model which is legally sound and effective. But of course, all depends on political will. And this is even more true after this year's Munich Security Conference and the U-turn of the US policy towards Ukraine. As lawyers, I think we have done a great job, and the conclusion is within reach. As I said, it is foreseen at the forthcoming meeting in Strasbourg, but ultimately it will be governments to decide whether they want to commit to what has been prepared. I take reassurance in the fact that earlier this week, 93 states voted in the UN General Assembly for the resolution, which emphasized strongly the need to ensure accountability for the most serious crimes under international law through independent investigation and prosecutions at national and international level. The crime of aggression is clearly among them. The Council of Europe model provides a sound legal basis, thereby closing the accountability gap for the supreme crime under international law. By providing support to the establishment of this tribunal, we defend the very values and principles this organization was founded 75 years ago. In 1949, the founding states of the Council, among them the Irish Republic, adopted a statute whose preamble expresses the conviction, and I quote, that the pursuit of peace based upon justice and international cooperation is vital for the preservation of human society and civilization. 75 years later, let us unite again based on this shared commitment to support our member state, Ukraine, fighting for its survival as a free and sovereign nation. Thank you very much for your attention, and I look forward to the rest of the presentations.
Thank you very much, Jörg. And I think the message is loud and clear. The Council of Europe is ready. The work has been done at a technical level. The question is the world ready? Are the member states ready? Congratulations to all involved in the core group, by the way. That leads us now to the next panel discussion. So I'd invite Shane and Declan, please, to join me up here, and I'll just run through some introductions. We will have four excellent contributors on this panel, two of whom will be joining us online from Ukraine, and two of whom are here with me today. So let me just run through, first of all, the purpose of this panel is to discuss really the prospects, politics and practicalities of the establishment of a special tribunal for the crime of aggression. I'll start from the far left. I'm very pleased to have Professor Shane Darcy with us, who is Deputy Director of the Irish Centre for Human Rights and a very good friend of mine, where he teaches business and human rights, international humanitarian law and criminal law. He's the Programme Director for the LLM in International Criminal Law and the PhD programme at the Irish Centre for Human Rights. He's been a visiting scholar at the Central European University, Harvard Law School, University of Queensland, and many others. He's the author of several very high-profile books, including Judges, Law and War, The Judicial Development of International Humanitarian Law, which is published by Cambridge University Press, and To Serve the Enemy, Informers, Collaborators and the Laws of Armed Conflict, published by Oxford University Press in 2019. We also have with us Declan Smith, who is the legal advisor at the Irish Department of Foreign Affairs. It's a pleasure to have you with us, Declan, also. Declan has been the legal advisor at DFA since 2021. But prior to assuming the current position, he was the deputy legal advisor in the department. He was the chair of Ireland's National Committee on International Humanitarian Law from 2008 to 2020, and also chaired the European Union's Working Party on the Law of the Sea during Ireland's EU presidencies in 2004 and 2013. He served as the Deputy Permanent Representative of Ireland to the United Nations at Geneva and has had diplomatic assignments in Madrid and Tehran. He is a member of the Permanent Court of Arbitration and is currently Vice Chair of the Council of Europe's Committee of Legal Advisors on Public International Law, which is also known as CADI. Then turning to the screen, and I'm not sure, do we have Katya and Anton on screen? But let me start with Katya. Dr. Katerina Busol is an associate professor. She's a Ukrainian lawyer and associate professor at the National University of Kyiv, Mohila University Academy. She's a British Academy research fellow and at the British Institute of International and Comparative Law, and a legal advisor to the International Centre for Transitional Justice. As a practicing lawyer and scholar, Katya has worked on conflict-related sexual violence, crimes affecting cultural heritage, direct and public incitement to genocide, and Ukraine's transitional justice process.
She has worked with UN Women, Global Rights Compliance and Truth Hounds, and advised Ukrainian prosecutors and judges on armed conflict-related proceedings. Katia was a fellow at Chatham House and is a visiting professional at the ICC Office of the Prosecutor. Katia, it's a pleasure to have you online. And lastly, but he may not be with us yet because of other government business at the moment, but hopefully will join us later, is Dr. Anton Korinievich, who is an Ukrainian lawyer specializing in public international law, international humanitarian and international criminal law. He is ambassador at large at the Ukrainian Ministry of Foreign Affairs and has served as Ukraine's state agent before the International Court of Justice in respect of numerous international proceedings. Anton is also head of the task force working group on freezing, seizure and confiscation of Russian assets within the Prosecutor General's office. And he's previously served as permanent representative for the president of the Ukraine in the Autonomous Republic of Crimea. Finally, and importantly for this conversation, he is also coordinating the issue of the establishment of a special tribunal for the crime of aggression against Ukraine within the Ministry of Foreign Affairs of Ukraine. So with that, I want just to give a very, very warm welcome to all panelists, and I'll just join them now. Yes, it is. Katia, can I just do a sound check? Can you hear me loud and clear? We don't hear you. I'm not sure if you're muted or if it's on our side with the speakers. Are you on mute, Katia? Just double check that perhaps. Okay, maybe we'll turn to Declan. I'll come back to you in a moment, Katia, if that's all right. We might just try to get that sorted. Sorry about that. Okay. Can you unmute now, Katia? Can we just test if we can hear you?
Yeah, I think it works now.
Excellent.
Can you hear me? Apologies for that.
No, don't worry. This is a small blip on our program, so don't worry in the slightest. Katia, I'm so pleased that you're with us, and of course we would love to have you in the room, but thank you for making the effort to join. Can I just start with you, Katia, please? And when we think about the idea of prosecuting the crime of aggression and more generally accountability for what's happened in Ukraine, victims' voices are so often absent in our discussions about accountability. So I suppose my question to you is, how do we ensure that victims' voices and that a victim-centered approach to justice and accountability in Ukraine?
Thank you very much for your question, Andrew, and thank you generally for convening such an important event amid these unbelievable and dangerous times. And I just want to express my gratitude and deep admiration to Ireland and the Irish people for your exceptional support for Ukraine and for your principled stance on other devastating atrocity situations globally. And I'm grateful that we are starting the discussion with the victims, with the people, because they have been the driving force behind all the justice initiatives in Ukraine. And I would really like to stress that both before the full-scale invasion and since 2022, both the Ukrainian public and crucially atrocity survivors have demanded accountability both for direct perpetrators of alleged war crimes, crimes against humanity and genocide, but also for political, military and propaganda architects of the overarching crime of aggression. So, for instance, the recent sociological polls show that up to 76% of Ukrainians believe that justice cannot be reached without the accountability of those who designed that attack on Ukraine and perpetrated the ensuing conflict-related crimes. The same strong voice comes from the Ukrainian leading human rights NGOs who, despite the change of the administration across the Atlantic, have also not changed their stance on the need for the wide-ranging accountability from prosecutions to reparations with respect to both atrocity crimes perpetrated on the ground, but also with respect to the underlying crime of aggression. And this demand is shared by the SEMA Network Ukraine of Ukrainian Survivors of Conflict-Related Sexual Violence and by the Association of Ukrainian Male Survivors of Torture. So I really wanted to paint this broader picture that it's not just that we need to look for the ways to reach out to the people and survivor groups in Ukraine in terms of what their preference to justice is. They're really there already telling us how much they demand prosecutions and reparations for all four core international crimes. And I would just underline two innovative things that have happened in Ukraine recently, and they really concern also the crime of aggression. First, that Ukrainian civil society and survivor groups have been working on individualizing our view at what aggression is and what the harms of aggression are. So, for instance, in 2024, so the survivor groups from Vinnytsia, Truth Hounds, Clooney Foundation for Justice, and Law Legal Action Worldwide have brought an innovative claim before the Human Rights Committee, arguing that an attack on Vinnytsia, which is part of Russia's wider aggressive attack on Ukraine, and the ensuing deaths of civilians and the military personnel from that attack, were the violations of the right to life as envisaged under the ICCPR. In the same way, Ukraine is advancing reparations internationally and domestically under the Urgent Interim Reparation Scheme. And survivors are also saying that while the Urgent Interim Reparation Scheme launched domestically remedies harms ensuing from war crimes, crimes against humanity, and possibly genocide, the wider harms from sexual to reproductive harms ensuing from the crimes of aggression, which do not fall within the scope of war crimes, crimes against humanity, and genocide. And therefore, survivors are also really willing to see those crimes verbalized, visualized in the prosecution within a future aggression tribunal, and of course also to be remedied through that tribunal. Thank you very much.
Thank you, Katja, very much for those remarks, and I think it gives us a very important context for the discussion. I'll come back to you, Katja, with a question shortly, but I might just turn to Declan now. Declan, there was a very, I think, strong and decisive message given by the Minister this morning. Follows up what Ireland has said, Taoiseach, in the agreement in September and so on. Can I just invite you to say a couple of introductory remarks about what your position and your thoughts are on this general issue first?
Sure. I know Schieffer pointed out how low that podium was, so maybe I'll do this from the chair. Thanks very much, Andrew, and thanks to DCU for convening this very timely event and for giving us the opportunity also to use this magnificent new building, I think for one of the first times. Firstly, I think it would be helpful to set out briefly the legal analysis that informed the Irish government's policy response to Russia's full-scale invasion of Ukraine 3 years ago. Ireland has been quite clear from the outset that the invasion was an act of aggression, and that Ukraine was and remains a victim of aggression. As such, Ukraine was entitled to the assistance of other states pending action by the United Nations Security Council to restore international peace and security in accordance with the UN Charter. That, of course, has not happened, and as the aggressor is a permanent member of that council, and as such, it's able to veto any action the council might consider. Secondly, aggression is a crime under international law for which individual political and military leaders may be held personally liable. Ireland has for many years been a strong supporter of accountability for international crimes, and in particular, a supporter of the International Criminal Court. In the invasion of Ukraine, we could see not just an act of aggression, but also very strong evidence of the commission of war crimes and crimes against humanity. The jurisdiction of the ICC in Ukraine was, however, limited by two factors. Ukraine was not at the time a party to the court's statute, and secondly, even if this factor could be overcome, at the time, the court's exercise of jurisdiction over the crime of aggression is subject to specific restrictions, and that created a challenge in addressing the crime of aggression. Ireland was one of 40 states which in March 2022 referred the situation of Ukraine ourselves to the court, which allowed the court there to the prosecutor to immediately begin investigations of the situation in Ukraine without having to rely on the authorization of the court's pretrial chamber, which would have been necessary where a state which is not itself a party to the court statute refers or tries to refer the situation to the court. So although the prosecutor could now formally begin his investigation into the situation in Ukraine, he was still limited by to investigating suspected war crimes, crimes against humanity and genocide only. The ICC may only exercise jurisdiction over the crime of aggression where both the victim state and the aggressor are parties to the Rome Statute, and at the time, of course, neither Ukraine nor Russia were parties to the statute. It was to address this, what's called an accountability gap, that the need for a special tribunal became so compelling. So the third thing I should point out is that the war in Ukraine has coincided with a period since 2022 of intense, by Irish standards, intense participation in international legal proceedings, both under the last government and the current one. Just to give you a sense of what Ireland has been doing on this front, not only did we join with others in referring the situation in Ukraine to the ICC, we intervened as a third party also in Ukraine's proceedings at the International Court of Justice against Russia under the Genocide Convention. And we subsequently intervened in the Gambia's case against Myanmar and South Africa's against Israel under the same convention. We've participated actively in advisory proceedings before the International Court of Justice on the question of Israel's policies and practices in the occupied Palestinian territory. And we submitted observations also to the International Criminal Court on the prosecutor's application to the pretrial chamber of that court for arrest warrants in the situation of Palestine. We expect shortly to file a written statement in the latest advisory proceedings at the ICJ on Israel's obligations to the United Nations and other international organizations in the OPT. This level of active participation in international legal proceedings reflects Ireland's commitment to international law and its support for the system of international courts and tribunals established to resolve international disputes and, in cases of international crimes, to try those most responsible. The accountability gap with respect to the crime of aggression against Ukraine was of concern to Ireland and many other states. There was agreement at the European Council for the creation of an appropriate mechanism for the prosecution of the crime of aggression. And our view in Ireland was that the appropriate mechanism should be a special tribunal. And we were happy to join the core group that began work to create that tribunal under Anton's chairmanship. The group now consists of approximately, as Jörg has told you, the group now consists, I think, of 40 states, mainly Council of Europe member states, but also, importantly, the United States, Australia, Japan and Canada, who've all been, up to this point, very active participants. There have been numerous meetings of the core group since it was established in early 2023. While early meetings considered different models for a special tribunal, we have now reached, as Jörg has said, agreement on the model of tribunal. And now that all that really remains to be negotiated are the details. There is quite an interesting legal architecture for the tribunal. It'll involve a central and novel role for the Council of Europe, which is very welcome. And
The architecture consists of a bilateral agreement between the Council of Europe and Ukraine, which will establish formally the tribunal. As Jörg said, annexed to that agreement will be the statute of the tribunal, which will set out important elements of, for instance, the court's jurisdiction, its composition, and the procedure for the conduct of trials. Separate to that, there will be what's called, this is a unique Council of Europe instrument called an enlarged partial agreement. It's not formally on the plane of international law to be regarded as a treaty, and so it has practical advantages. It allows for very early completion of internal domestic procedures for participation. It isn't subject to ratification, although we suspect in Ireland that given the charge on public funds it will involve, it will be treated as an international agreement in Ireland for the purposes of the Constitution, albeit not a treaty on the plane of international law. And then finally, there will be individual cooperation agreements to be concluded between states and the tribunal itself, which will enjoy international legal personality for the purposes of concluding these agreements. And these agreements are essential to the court's operation. They will involve placing obligations on states to cooperate with the court in, for instance, the collection and provision of evidence, the arrest and surrender of suspects, and very importantly, as far as our Dutch colleagues are concerned, who will host the court, the execution of sentences. That work we hope to be able to complete. It's quite a lot, obviously, but we hope to be able to complete that over the next month or two. I'll just conclude by saying that the tribunal is essential not just to close the accountability gap, but to demonstrate the commitment of the states involved to the international legal order. And for these reasons, we're determined to bring this work to a successful conclusion. Thank you very much.
Thanks, Declan. Thanks very much, Declan, for that. Shane, turning to you, if I may, and I'm sure you have got things you want to say, but we have to ask the question: in this current geopolitical climate of chaos and uncertainty, and is justice in Ukraine possible to achieve through judicial means?
Yeah, thanks, Andrew, for the invitation to speak and to join such an eminent panel of experts and practitioners today. Talking about the Special Tribunal, it's a little like a game that my 8-year-old son likes to play with me called Mystery Box. You say, would you like a brand new bicycle or what's in the mystery box? You don't know what's in the mystery box. And I'm only getting to learn, including some of the comments today from Jörg, about what exactly is the Special Tribunal going to constitute, which I'll come back to in a moment. But your question about the geopolitical era that we're currently living in, from an international criminal justice perspective, we're in a very momentous, indeed precipitous time. The International Criminal Court in the past 2 years has issued arrest warrants for a sitting head of state, of a permanent 5-member of the Security Council in Russia, and also the closest ally of another permanent 5-member, the United States. I'm talking about Israel. The response, therefore, has been, particularly from the United States, has to be politically and financially to attack the International Criminal Court. Staff are now being paid months in advance to protect them. If you look at filings before the ICC, the names of the lawyers are all being redacted, such as the risk that they face as individuals engaging with work at the International Criminal Court. In addition, we see member states of the ICC, Council of Europe members amongst them, who are undermining the work of the court. So Italy, for example, recently not acting on an arrest warrant for a Libyan national. Germany talking about inviting Netanyahu to Germany, despite the fact that he is facing an ICC arrest warrant. So we are facing a serious existential threat in the realm of international criminal justice. So the question of a special tribunal, if it were to be established, it would indeed be historic. We have not seen, and this has been mentioned already, any ad hoc tribunal with jurisdiction over the crime of aggression previously. And if senior Russian military and political leaders were to be prosecuted, that would also be historic, because we've not seen anyone prosecuted for 75 years for the crime of aggression. There's a lot of justified rhetoric around the crime of aggression. The Nuremberg Tribunal famously said it's the supreme international crime, for it contains within itself the accumulated evil of the whole. And that's an entirely apt description, and it's one that has been used in the context of Ukraine also. But in practice around the crime of aggression, we've seen states, particularly powerful, militarily interventionist states, do their utmost to restrict the capacity from a permanent institution like the International Criminal Court to prosecute the crime of aggression. So Declan referred to the restricted limitations on the ICC statute. Jorg referred to the impunity gap earlier. Those are not accidental. Those are not oversights. That's the way it has been constructed. So the ICC has never prosecuted a case of aggression. It's never even opened an investigation because it can only do so with relation to about a third of the states that are states party. And that's part of the design. That's part of the design of it. So it seems into this breach, in some ways, Ukraine has been forced. So Ukraine is obviously a victim of a crime of aggression, an act by its character, gravity, and scale that constitutes a manifest violation of the UN Charter. There's very little doubt about that. But Ukraine is also forced into the problem of having to deal with an inefficient international legal system when it comes to prosecuting that crime. So with regard to the Special Tribunal itself, its establishment seems to be getting a little bit closer in relation to some of the discussions we've heard today. There's obviously has been ongoing for over 2 years discussions amongst the core group about the form that it would take, whether it be international or internationalized, whether it be General Assembly involvement. Obviously, the Security Council won't be involved. The Council of Europe is playing the key role in this regard. The slow pace of progress, I think, is reflective, I should say, of perhaps disagreement amongst the states that are involved. It took the four allies after the Second World War from the summer of 1945, when they met in London to devise the Nuremberg Charter, from then until when the judgment was issued was 16 months. Obviously, it's not entirely comparable, but I think the delay in terms of advancing a special tribunal statute is related to disagreements around some of the key legal issues. Jorg has mentioned a couple of these, the issue of immunities, also the issue of in absentia trials. Whether the tribunal will come into existence or not is a big question. The United States is, of course, part of that core group. And in recent weeks, we've seen everything being turned around and turned upside down. Joe Biden welcomed the ICC arrest warrants against Putin. We don't know what Donald Trump is going to do, literally almost on an hourly basis. And then the other big even if this tribunal is created, and there's questions then about legitimacy as well, which we might come back to, is it likely that a senior Russian political or military leader will face trial before the court? Jorg today just mentioned clearly that the issue of personal immunities on which international law is not settled means that the core group is not endorsing that the tribunal would be able to waive those personal immunities or push them aside. So it's not going to be the troika, the three senior individuals. It will be someone lower than that. But Ukraine is not going to obtain a complete military victory over Russia. So it's more than likely that we'll see in absentia trials. And while in absentia trials have a place in the domestic practice in Ukraine and in other countries, it's not something that international criminal justice has really supported. They can't take place at the International Criminal Court. We have these proceedings in the Kony case at the moment, but they're pre-trial in nature. The Special Tribunal for Lebanon did have in absentia trials, but it was a highly expensive tribunal and was ultimately a failure. So again, I come back to the point that I made earlier that Ukraine in many ways has been forced into this dilemma. We have an international criminal justice architecture that has deliberately left aggression to the side, and Ukraine, I think, is paying the price in some ways.
Thanks, Shane, for a bit of a sobering analysis, but very, very helpful. Can I just ask, is Anton with us? Anton's not with us. Okay. May I come back to you, Katja, please? I mean, the question on the tip of my tongue, of course, is around your perspective, the perspective of a Ukrainian lawyer, an activist, and so on, in relation to the establishment of a special tribunal. But I'm also linked to that, interested to know what your views are on the role of the European Court of Human Rights, because we've had quite a focus on that in terms of the establishment of justice and accountability, particularly now that Russia is no longer a member state of the Council of Europe.
So I'd be welcome your thoughts on those issues, Katja.
Thank you, Andrew. As Professor Schiffer-Olieri has noted earlier, Ukraine has made international law a central piece to its response to Russia's aggression, in particular during what I call the first phase of Russia's aggression between 2014 and 2021. So Ukraine as a state, and us as the human rights lawyers advocating for survivors, we were trying to activate all measures possible to get certain redress and certain measure of accountability. And the ECHR is particularly important in one dimension here, not only because it allows both the interstate track and also the individual complaints track, but also because it has really centered on the first phase of Russia's aggression. There's unfortunately, in terms of the discussion of accountability and reparations, oftentimes the focus on what Russia has perpetrated since 2022, that in a way, this temporal limitation that we are currently having with the ECHR allows us to focus really on the first phase of Russia's aggression and ensuing harms. For instance, both sadly and symbolically, it was the important pronouncement from the European Court of Human Rights in the joint case of Ukraine and the Netherlands versus Russia in late 2022 that established that Russia did have effective control over eastern Ukraine. And almost at the same time, we had a domestic judgment from a Dutch court in the case concerning the downing of the MH17 flight, which also found that Russia did have effective control over parts of eastern Ukraine. And I really resonate here with what Professor Shindazi has just said, that in a way Ukraine was also part of the wider game and damaged by this whole infrastructure, because obviously the Ukrainian lawyers and policymakers were saying that there has been Russia's presence in eastern Ukraine and in Crimea since 2014, but it took reputable domestic courts and reputable regional courts like the ECHR in 2022 to seal it also for the international community that the Russian presence was there. So the ECHR remains an important track for us for individual complaints and for interstate arguments. And Ukrainian human rights groups have also made a research about Russia's weaponization of ECHR and the submission of evidence alleging mass violations by the Ukrainian side. So there are many interesting dimensions that we can explore within the ECHR framework, and it remains really relevant for Ukraine despite the time limitation which you have mentioned. Thank you very much.
Thanks, Katja. Oh, excuse me. Thanks, Katja, very much for that. And actually, Declan, if I can come directly onto you then, as a follow-on from that. I mean, Ireland in the past has spoken about, and I think it's implied in what we're discussing here, actually, this risk of fragmentation of international law and international judicial mechanisms. I mean, how do you see this issue? And is there anything that can be done to reduce the risk or minimize that risk of fragmentation?
Well, hello. Yeah. Ireland has expressed concern over the years on this question of fragmentation of international law, or at least the possibility or potential for the fragmentation of international law. It stems primarily from our perspective from the proliferation of tribunals, and where, for instance, you might have new legal instruments. The Convention on the Law of the Sea, I think, is probably a very good example, where states simply couldn't agree on how disputes between them on the interpretation and application of what is essentially the constitution of the oceans and regulates all human activity in, on and under the seas. They decided that there should be three separate means for resolving disputes in addition to negotiation and mediation. The International Court of Justice was one such means for compulsory resolution of disputes. The states also created ITLOS, the International Tribunal for the Law of the Sea, And in addition to that, they had the choice then of appointing bilaterally between them, in the case of any given dispute, a separate ad hoc tribunal called an Annex 7 tribunal. And the risk that this sort of variety of different means of dispute resolution created for the consistent interpretation and application of a very large body of law, such as the law of the sea, is that you'll have different tribunals and courts coming to different conclusions on the same law. So where, for instance, we have been engaged in creating the Special Tribunal for the crime of aggression against Ukraine, that concern is partly alleviated by the fact that currently the International Criminal Court, which is, I think, would certainly be our preferred method for dealing with this, doesn't currently have jurisdiction over this particular act of aggression. Now, there is, as you probably know, an initiative underway, timed for this year's review conference of the statute of the International Criminal Court to amend the statute to allow for the court to exercise jurisdiction over the crime of aggression where only the victim state is a party to the statute. So that would obviate the need for instance, in this case, Russia actually becoming a party to the statute before the tribunal or before the ICC could exercise jurisdiction over this crime. So it's something we just have to keep our eye on. A lot of this is dictated by political preferences. We can't, international law, of all branches of the law, international law is particularly subject to the political environment in which it's created, and trying to reach a consensus among states, each of which effectively can decide not to be bound by the creation of a new rule of law, is always going to be challenging. And inevitably, therefore, you have multiple different means of resolving disputes likely to be considered.
And I suppose, thanks, Declan. And I suppose that is that square peg into a round hole kind of analogy is what led us to the development of previous special kind of courts, Shane. And I guess thinking about the experience and the lessons we've learned from other courts, I mean, what should be borne in mind if this special tribunal is to come to fruition? And I might then open up to the floor to questions, actually.
Yeah, thanks, Andrew. The experience of other special tribunals or ad hoc tribunals is certainly relevant in some respects, even though, as we've mentioned, none of them have prosecuted the crime of aggression just yet. It's kind of striking that the first creation of an ad hoc tribunal was in 1993, when we saw the return of war to Europe, and it sort of spurred on this development of the 1990s of the various ad hoc tribunals. Some of the key issues looking back on them is the need for adherence to fair trial human rights standards, the need for clarity around the legislative instruments that govern them. I suspect that that's part of why we're seeing such time taken with the special tribunal. One of the things that the previous tribunals didn't really have a role for, aside from the Cambodia tribunals, is the issue of victims. And Katja has already talked about this a little. And I'd be interested to see within the mystery box that is the instruments, what is the role for victims in the context of this special tribunal? At the International Criminal Court, victims have a particular role to play in terms of participation in proceedings, but also with regard to receiving reparations. I would strongly be encouraging that, should a tribunal be going ahead, that there should be a role for victims. There is some criticism that it adds to delay, but often that criticism is not justified. But I wouldn't be advocating that there be any role for reparations via the special tribunal. At the ICC, reparations are tied to prosecutions, successful prosecutions. There have been half a dozen in the 20-odd years of the International Criminal Court statute. I think the special tribunal shouldn't deal with reparations. They should be something dealt with the likes of the claims commission that have been mentioned. Someone being entitled to reparations for the destruction of their home or other harms that have been caused as a result of the aggression shouldn't have to wait on the admittedly unlikely prosecution of an individual for that. I think as well it's important not to focus only on the international in this context. In the aftermath of the genocide in Rwanda, Rwanda pursued what was called a maximal accountability strategy. prosecutions before an international criminal tribunal, before domestic criminal tribunals, as well as a gacaca process, a justice process dealing with many thousands of perpetrators. Ukraine have followed that maximal approach in some ways. We've already heard from Professor O'Leary about the various courts that it's been involved in, ECHR, ICJ, ICC, as well as domestic proceedings as well. And in relation to domestic proceedings, we have seen talk of hundreds of individuals susceptible for prosecution, not just for war crimes or crimes against humanity, but also for the crime of aggression. So you'd be a little concerned with some of these because of aggression constituting a leadership crime. And one of the other things we see as well in Ukraine is the prosecution of Ukrainians for collaboration with Russian authorities. I think there's also a risk of trials taking place of those that can be tried, because you can get your hands on people. It's far easier for Ukrainian authorities to get their hands on Ukrainian nationals than it is on Russian nationals. So I think that's something to be borne in mind, is to think about the broad spectrum of judicial responses that can take place.
Thanks, Shane. I am actually going to not open for questions now, because I've just heard that Anton is with us online. Can I just do a sound check with Anton? Are you with us? And can you hear us? And can we hear you? Hi, Anton. Sincere thanks to you for joining us, Anton. I guess I'll just throw the floor straight over to you, Anton. What are your thoughts? Where is your head at now at the present moment in time in relation to the Special Tribunal? Over to you.
Yeah, thank you so much, Andrew, for your kind invitation to participate in this important event. It's great to be on a panel with many friends, and I'm sure that this event is very important. And throughout these days, when we talk about this 3 years of full-scale invasion, it's really important that in the capitals of our friends, we have discussions about justice and accountability. And I think that this is crucial, because we believe that justice must not be compromised. So understanding that no war has lasted forever, and hopefully there will be the end of the war, of the Russian aggressive war soon, we believe that justice should not be compromised, and accountability must take place, and the justice should be restored. So thank you for this. Well, going straight to the question of the Special Tribunal, of course, with Declan, Katya, and yourself, and Shane, of course, I understand that maybe it's better to talk about our understanding on how do we move forward, and what may be the perspective agenda for us. So I think that the core group for the establishment of the Special Tribunal, which we gathered 2 years ago, is a very good platform, which really enabled us to find the best possible and feasible solution for the creation of the Special Tribunal. Here, I must admit, of course, that all international lawyers are idealists, and this is good. But I think that no tribunal was and will be ideal. And so I think that we should not speak about the ideal formula, but we should speak about the formula which enables us to create effective tribunal which will be able to do the job. So I think this is what we are doing in the core group, and with participation of representatives of 41 states, including Ireland. Declan, we appreciate the input and the important participation in our discussions. And with several international organizations engaged, we really tried to find the best possible variant. And I think we found it. And I believe that this is not only us, Ukraine, thinks that we found it, but also our colleagues in the core group. So we do consider that the best feasible option is to establish the tribunal on the basis of bilateral agreement between Ukraine and the Council of Europe as a international legal entity, let's say, yes, as a subject of international law. And the tribunal must have the legal personality under international law, so that it's not part of Ukraine's or any other state's national legal and judicial system. This bilateral agreement between Ukraine and the Council of Europe, we believe, is a good framework for the establishment of the tribunal, also because Russia was a member of the Council of Europe, both when the Russian aggression started in 2014 and when the Russian aggression escalated in 2022. So we believe that Council of Europe does have this both moral and political and legal grounds to do this. So we believe that this agreement should be the basis for the establishment of the tribunal, and the statute of the tribunal should be annexed to the agreement. So it should be 2 in 1, actually, as in many cases in the practice of international law with other courts and tribunals which dealt with international crimes. The third element of this package within the Council of Europe system, we believe should be the enlarged partial agreement, the EPA, which would deal with administration and management for the special tribunal. So which would include members and associate members. So through this mechanism of EPA, our international partners will be able to participate in the tribunal's work and life, and will be able to support it, including, of course, financially. Maybe not the part of the package, but also very important element for the establishment of the tribunal should be the cooperation agreements between tribunal and states and international organizations, because we, of course, understand that it's not only important to establish a tribunal. It's important that the tribunal can do the job, and the tribunal will be able to do the job when states have the solid legal basis for the cooperation. So I would say we have 3+1 elements: bilateral agreement between Ukraine and the Council of Europe, statute, enlarged partial agreement, plus cooperation agreements, which I believe present a good framework for the establishment of the tribunal. Now, we do believe that we will be able to make the job, though, of course, it's not the most easiest task in the world. And of course, we also feel enthusiastic with the leadership role of the Council of Europe in the process. So since our today's topic is about Council of Europe, yes, so legal service of the Council of Europe very actively participates in the work of the core group. We have the support by the Committee of Ministers of the Council of Europe with the adopted decisions. We have the very strong position of the Mr. Secretary General Alain Berset, who recently proclaimed that the establishment of the Special Tribunal should be one of the priorities of the Council of Europe for 2025. And we actually believe that in 2025 we can do the job, meaning legally establish the tribunal and for it to start its functioning. So we believe that we do have this moment which we need to catch. We had a very good and productive core group meeting in Brussels in the beginning of February. I'm sure that a lot of you in the room are aware about this, and there were many media coverage and press conference and a lot of comments by, in particular, EU leadership and Ukraine's leadership on this issue. And we actually, in Brussels, set forth the basic principles for the Special Tribunal, how to move forward with its establishment. Now we are moving closer to the next core group meeting in March, where we hope we will be able to finalize our legal and technical work. So the core group is not a decision-making body, so we are not making political decisions. Our job is to produce papers, produce texts. So we hope that after the core group in March, and after maybe spending not so much time on legal polishing and scrubbing, we will be able to present these 3 documents, which I mentioned, to the political leadership of our nations, of Ukraine, Ireland, and others, so that we might have the feedback from our political leadership, whether this is something with what we move forward. And I hope that if we get the signal of political support and political will to engage in the Special Tribunal issue with real text on the table, then I think we really have good chances to establish the tribunal in 2025. So, so talking about this, I hope that we will move forward expeditiously. We, of course, count on support of our friends and colleagues who are working in the core group. Again, our gratitude and appreciation to Ireland, and in particular to Declan and his team. Yeah, we just actually, President just instructed us yesterday. We yesterday had a video conference of the core group, and just before that, the President instructed us, and he said, full steam for the Special Tribunal, move forward, do the job as quickly as you can. So with this instruction by the President, we are moving forward. Thank you, Andrew.
Anton, thank you so much. And full steam ahead. Okay, well, let's quickly, because this is too good an opportunity, let me open the floor to questions. I'm going to gather 3 or 4 and we will run on a little bit over time, but I think it's important. So let's start here and let's kind of move our way across. The blonde lady and lady in the green. So yourself first.
Thanks. Thank you very much. It's really interesting. It's Lisa O'Carroll from The Guardian. Could any of you just speak to the point about the role the US plays in this? It has observer status, doesn't it, with the Council of Europe? So why does the support, can you just talk about why the support of the US is critical to the success of our establishment of a tribunal? Thanks.
Thanks, Lisa. We'll gather the 2 other questions and then we'll open it to the panel.
Thank you very much for the very interesting discussion and comments. Anna Vangelleri, PhD in International Law from the CU. So a Council of Europe-based special tribunal for the crime of aggression would be a regional rather than a truly international approach to prosecuting the crime of aggression. What might the implications be of this regional framing for the perceived legitimacy and authority of the tribunal, especially among non-European countries? And if this regionalization could inadvertently reinforce narratives of Western European justice as opposed to universal accountability. And a second question, if I may, what the aspiration would be about this tribunal setting a precedent, regional human rights organizations establishing permanent mechanisms for prosecuting international crimes for future conflicts, I mean, if successful. Thank you.
Thank you very much. Molly Brady-Martin from Save the Children, the humanitarian organisation. And my question is, unsurprisingly, around the accountability gap for children. We do know that children are uniquely vulnerable to the effects of conflict, and they have therefore a lower threshold of harm than adults, whether that's because they're 7 times more likely to die of explosive weapons or they die faster from the effects of malnutrition, dehydration. And I would say we really welcomed Ireland's reference to this vulnerability in the recent ICJ interventions. But by and large, children remain invisible in accountability mechanisms. And I suppose my question is, if and to what extent the core group has been cognizant or aware of this kind of child rights sensitivity lens in shaping a model for a special tribunal, and even, as Shane says, right down to victim participation and child participation in accountability mechanisms. Thank you.
Thanks very much. I think that was the 3, or was there any one more? Or that's okay. Let's hold there for a moment. And can I ask the panel? I'm not sure who to go to here. I don't want to put anybody under pressure, but if you can shout. The first question is a very pertinent one. Is about how important is it the role of the United States in this process? Does anybody want to take that? Declan.
Well, I might answer that and combine it with an answer to the second question as well. And Anton may want to say something in addition. The objective at the outset was to have the broadest possible participation in the creation of the Special Tribunal, partly to ensure its legitimacy. And so it was essential that a broad range of states participate in the creation of the tribunal. And of course, the United States is an extremely important country. The G7 took a very active role in the negotiations, and the United States, among them, a leading role. Rich Fizek, who is the current acting legal advisor in the State Department, played an extremely active and constructive role throughout. The United States was very, very important. And but quite aside from its role, there was a determined effort to broaden the appeal of the core group as widely as possible. So I think, as Jörg has mentioned, we have Guatemala and Costa Rica, for instance, participate. But the mechanics of the negotiations themselves perhaps militated somewhat against a broader participation of states, because each meeting was hosted by an individual country, invariably in Europe, and for states to be represented from all over the world for what were essentially 1.5-day meetings every 2 months in a European capital was that really did stretch the resources even of smaller European countries. So that was a big factor in it. But we have now over 40 states, and it is certainly from the perspective of Europe, it enjoys very broad legitimacy within Europe and further afield, and that has been a very important part of the negotiation.
Yeah, I might jump in on that as well, Andrew. So the US has been hot and cold in special tribunals over the years, sometimes funding, supporting them, providing staff and personnel, and then going to the outright hostility that we've seen in relation to the International Criminal Court. The absence of hostility might allow the special tribunal to go ahead. Hostility would certainly be harmful to it. But I do think there is a question about legitimacy. So on one level, the special tribunal sounds like a European court for a European war involving a former Council of Europe member waging a war of aggression against the Council of Europe member. So in some ways it is legitimate in that respect. But there are members of the Council of Europe, there are members of the core group who have, as I've mentioned already, have acted decisively against prosecuting the crime of aggression or giving an institution like the International Criminal Court jurisdiction over the crime of aggression. Now about 30, I think, of the Council of Europe members have signed the aggression amendments to the Rome Statute. So Ukraine amongst them, Denmark just recently with all this talk about Greenland, etc. But there are Council of Europe members who've been involved and core group members who've been involved in, let's say, for example, the war in Iraq, which is the previous clearest example of the commission of an act of aggression. I was really struck when I went back and looked at the statement from 2002 by eminent legal personalities and politicians regarding the creation of a special tribunal put forward by Philippe Sands. The first name on the list is Gordon Brown, who was Chancellor of the Exchequer under the Blair regime when they went and sent 46,000 troops with the US to wage an illegal war in Iraq. So there are legitimacy questions when you have states involved in the creation of a crime of aggression tribunal that themselves have a case to answer. With regard to regionalization, there is a risk if we're moving away from internationalization because, of course, members of that region, Council of Europe, are less likely to use force against fellow Council of Europe states. We've seen European states using force outside of Europe, in Syria, in Iraq, as I mentioned, as well as their allies, such as Israel in relation to Palestine. So the legitimacy arises in that context as well. And we don't see a big clamoring for the creation of an international claims commission by states to deal with what's been taking place in Gaza. And there's a double standard at play. Declan mentioned Ireland's very valuable interventions in the ICJ and the ICC. The ICC referral of Ukraine had 40 states. The ICC referral in relation to Palestine, which wasn't really needed, but still it only had half a dozen states. So there's definitely double standards at play. There was an attempted regionalization of international criminal justice with the African Union creating a protocol and creating a criminal chamber. That never got off the ground. I would firmly favor fixing, and this would be part of the core group's kind of moral mandate, is to get their own houses in order when it comes to, for example, the International Criminal Court and its jurisdiction. So the harmonization that Declan talked about at the forthcoming meeting, I think that will be important to fix the problems in the Rome Statute when it comes to the crime of aggression.
Thanks, Shane. Could I just ask either Katya or Anton to come to the question of our colleague from Save the Children, which I think is a very important one, and I know the Schiffer here also would like to make a comment. Katya or Anton, would you like to come in on that particular question?
Yeah, I may start briefly. Thank you so much, Andrew. Well, we all understand that the issue of victim participation in the issue of the crime of aggression is a very specific one. Because, well, it's not mass atrocity crime like in the case of genocide, crimes against humanity and war crimes. So you have whole the nation who are victims and the whole state. So, but we work on this issue of victims and victim participation. Well, children, of course, are among the victims. So, again, in relation to the crime of aggression, there are several, I would say, specific issues which we are trying to solve and to see how to move forward. But yes, victims and their participation and tribunals' actions in relation to them are there. And just a small remark on regionalization, the former question. Well, of course, there may have been the point and the position that the tribunal should have been established on the level of the, I don't know, United Nations by the UN Security Council. But we understand that we should look for something what is possible. So we believe that establishing such a tribunal on the basis of this bilateral agreement with the Council of Europe, and as I mentioned, opening the enlarged partial agreement for membership and associate membership for states from other regions, we believe that we would have states from not the Council of Europe region to be present there, and we believe that the tribunal will have the necessary legitimacy. Thank you.
Thanks, Anton. And maybe Katja, the word to you, and then I'll just give the floor to Shifra. We don't have Katja. Okay, Shifra, I might hand you the microphone then.
Thank you very much. I have one question for Declan and two observations. You mentioned, I think, 40 states have signed up. And what I'd like to, that means that not all Council of Europe states have signed up. But I have a more targeted question. Have EU member states not signed up? And if that's the case, it would be very useful to know which ones. Because I think that is partly an answer to the question that came earlier from the member of the British Embassy and to Professor Bates' answer. It's not just about justice in this situation, it's also about contagion. And that's one of the lessons that should have been learned from 2008 onwards within the Council of Europe and the European Union. So if you do know the numbers or the names, I'll leave you to decide which you want to provide. Regarding this is just an observation relating to children. There are complaints, very important complaints relating to children, which are at the heart of the Ukraine and the Netherlands against Russia case. You can see how the court dealt with these issues in the admissibility decision. But this is not a forgotten issue. It is on the table at the merit stage of Europe's regional human rights court. And then the second observation relates to a point which came up now with Shane's excellent intervention. The convention was the consequence of brutal conflict. It seeks to avoid brutal conflict. But let's not forget that the Ukrainian conflict was not the first on Europe's continent since the Second World War. We have Georgia against Russia and Russia against Georgia cases since 2008. We have, of course, the Ukrainian cases, 3 of which are still pending, and the thousands of individual complaints which are related to that. The Deputy Secretary General said about 4,500. My figure was over 7,000. But we have forgotten and very active conflicts in Europe. Transnistria, which will be a central question relating to the accession of Moldova to the European Union. Nagorno-Karabakh, of the 13 interstate cases pending before the European Court of Human Rights, 10 relate to Azerbaijan and Armenia, with Turkey involved in one of those cases. And that conflict, as you know, is not just a slow-burning one. There was considerable problems in 2020, 2022, etc. And the court has received multiple requests for interim measures in relation to that conflict. And the court is still dealing with the Balkans conflict, which we lived in our lifetime. Both the Court of Justice of the European Union, in fact, and the European Court of Human Rights are still dealing with the aftermaths of that conflict in many different manifestations. So I think the point about US involvement is very important, and the point about not fragmenting international justice systems, but the reality of it is that Europe has a very particular geographic and historical mix. And the political reality nowadays is that the Gaia Callas seem to have got it right a year ago.
Before you dare answer that question or respond, Charlie, can you give the microphone to Professor Fabrini? 30 seconds, Federico.
A very, very quick question.
It's the last question.
So I want to pick up on what Liz actually was asking. In a sense, as a lawyer myself, I very much see the logic of creating a special tribunal, but I want to ask a provocative political question, which is what are the risks of failure? And wouldn't that outweigh the benefits of a victory? And shouldn't that be factored in deciding whether to go down that route? Because I guess Shane was somehow pointing that out in his remarks. if this doesn't work, isn't that undermining even more international criminal law as a discipline, as a project, as an endeavor to introduce humanity in international affairs? And I suppose I'd be interested in asking also Anton, why did Ukraine delay so much its accession to the ICC? I believe it only happened in the autumn of last year, 2024. And I never understood why Ukraine was actually not joining the ICC before that, because if that had been the case, I think then we would have had a forum, despite with the limitation that Declan was pointing out, of an already existing institution with potentially jurisdiction. Of course, Russia is not part of it, but if Ukraine had been in, I think some legal arguments could have been made that the jurisdiction of international criminal law existed there. So I'd be interested in having those two issues addressed.
Well, maybe just to answer Shifa's question first, all EU member states, it won't come as a surprise to you, but all EU member states, bar one, are members of the core group, and that state is Hungary. Not all member states of the Council of Europe have been, Anton can correct me, he'll know precisely, but are participants in the core group. But as he said, the enlarged partial agreement instrument will remain open for participation by states as soon as it becomes operative. And I think we certainly in Ireland are hopeful that those Council of Europe member states that haven't been able to participate for one reason or another in the work of the core group will nevertheless wish to participate in the enlarged partial agreement. And we have to recognise that many, particularly smaller states, will have resource limitations that effectively preclude them from taking an active part in an ad hoc negotiation process like this. In answer to Federico's question about whether we should have embarked on this at all, I think it very much depends on how you define failure. But I think if failure is defined as the failure to successfully try Vladimir Putin in this tribunal, then I think that is not how members of the core group have approached this. It's not the only measure of success. And what's much more important is that states begin work to create a special tribunal in response to an outrageous act of aggression, and that should not go without response from the community of states. It's very important that this tribunal be established, regardless of how many people in due course it gets to try, because even if it can't try, or for whatever reason, anybody, that its mere existence, I think, will alarm anyone who may very well come within its jurisdiction, and act as a signal to those contemplating similar acts of aggression in the future that similar tribunals will be created to deal with them too.
So there was a saying when the International Criminal Court was created that the most effective ICC would be one without any cases, that they would be dealt with domestically under the principle of complementarity. I think for the Special Tribunal, it's the opposite. If it's created and there are no cases, I think it will be seen as a failure. It could be a hugely financially costly undertaking at a time when resources are at a premium in terms of rebuilding and restructuring Ukraine. Also, I think that's something that needs to be borne in mind. There are thorny legal issues. We're getting a sense of how some of those are being sidestepped as well. But Jorg didn't talk about in absentia trials, and I think that's probably an issue that would be of concern to people. It could question the legitimacy of the undertaking. So I think there is a possibility of a failure, and then, as you say, damaging to the international criminal justice system. As to Declan comments that it would send a message. It would send a symbolic message. We have this saying in the West of Ireland. The West of Ireland is a very beautiful but very poor place, and people often say, "Well, you can't eat the scenery." What I mean by that is a hugely expensive symbolic court is not going to necessarily bring the reconstruction and the resources that are needed for individuals as well as the state of Ukraine itself.
Thanks, Shane. Thank you, Shane. I'm going to hand the floor now for the very last word to Anton. I'm assuming Katya is not with us. Okay, so Anton, I'm going to hand the floor to you. I think there were a couple of specific points to you, but also just some general concluding reflections would be very, very helpful. Thank you.
Thank you very much, Andrew. So I will start with this question about accession to the ICC. Well, first of all, I myself am very proud and honored that finally we are there. And there are a lot of people in Kyiv who were working hard throughout even 20 years for making this happen. So I think that the main thing is that we are there and we are the members of the ICC family. Well, this should have been done before. And again, many people in the government supported this for many years. But I think things before the aggression in 2014, maybe this was not the top issue of the priority. And after the start of the aggression, you know, and after the recognition of jurisdiction under Article 12.3, and after the start of preliminary examination and then investigation, maybe it was felt that it might be enough because ICC was already in the process over the situation in Ukraine. And then there was this some political fractions which used the argument of not ratification of the Rome Statute, that Ukraine should not ratify the Rome Statute because in such a case, Russia would use Russian propaganda in order to flood the court with some materials and papers and documents, and Ukrainian soldiers will be taken to The Hague. So there are still political fractions in Ukraine who speculate on this issue. And I'm really glad that in autumn of 2024, we finally did this, notwithstanding their critique and their negative position. So I think this is the main thing. And as a general maybe comment to many questions, well, I think that the biggest damage to international law will be done if this aggression is left unpunished. So, I mean, look at this war. Look at me, who feels shaheds and missiles pretty much every night. So, I mean, if this is not aggression, which should be tried for, so what is aggression, which should be tried for? So, whether then the concept of the illegality of war or not principle of non-use of force, whether they exist in international law or they are just fictionary. So, I think that this would be the biggest damage. Of course, we also are concerned and we work hard in order for the tribunal to be a success. But we see that if we establish effective tribunal and if the support and cooperation from the states will remain after its creation, then I think it should be a success story. ICC, if the ICC changes jurisdiction over the crime of aggression, we are okay with that. But we are sure that it will not be able to cover the situation of the Russian aggression against us. And we are sure about that. And I think everybody knows this in the room and outside. So we believe that having representatives of 40 states on the table, several international organizations, and I think the success of the tribunal is not only the matter for Ukraine, but for all of them in the room, because they engage in this and we all want to see accountability and justice. So yes, there is always a threat, but I do hope that we will be able to mitigate all the risks which are there. Again, thank you so much for this great discussion.
Thank you, Anton. And indeed, we all agree, we all want to see accountability and justice. Colleagues, thank you so much for indulging to allow us to run over a little bit. We will have lunch until 2:30, but before that, please join me in sincerely thanking my illustrious panel, Katja, Anton, Declan and Shane, for this fascinating session.
Ladies and gentlemen, if you can please take a seat. Thank you very much. Welcome to all of you back here for this afternoon session of the conference, The Role of the Council of Europe in Pursuit of Justice, Peace and Accountability in Ukraine. My name is Federico Fabbrini. I am the Professor of Law at Dublin City University and the Founding Director of the Dublin European Law Institute. And it is my great pleasure to chair this session on human rights in areas of conflict, an inescapable reality for the Council of Europe, which features as keynote speaker Professor Michael O'Flaherty, the European Commissioner for Human Rights. Before introducing our keynote speaker, let me just take a minute to first and foremost acknowledge the work that my colleague Andrew Ford, Assistant Professor of European Human Rights Law here at DCU and a member of Delhi, has done to make this event possible, and also warmly congratulate him and his co-author for the book they've just published. I think a big round of applause should come here. I should say that Andrew approached me in autumn of last year with an idea to organize an event around the third anniversary of the beginning of the war. And I warmly endorse this as it's fully in line with the policy agenda of the Dublin European Law Institute. Just as an information, the Institute structures its work around four main pillars of research. A first pillar focuses on institutional questions, including withdrawal and enlargement. A second pillar focuses on artificial intelligence and data protection. A third pillar focuses primarily on economic and financial affairs issues related to economic governance in the European Union. And then finally, a last pillar is very much connected to human rights, peace and security as well. In fact, while Delhi was only established last summer, in the prior 2 years, the topic of the war in Ukraine had been very much at the center of the work of the Brexit Institute here at DCU, which I also founded and directed. And in particular, let me just remind the audience that in 2022, the year when the war started, the Institute hosted a high-level event on the war in Ukraine and the future of the European Union with Javier Solana, the former Secretary General of NATO. Moreover, exactly a year ago, we marked the second anniversary of the war with a major in-person event on EU common foreign security policy 2 years after Russia's invasion of Ukraine, featuring Federica Mogherini, the EU High Representative for Foreign Security Policy. And just more recently, the Institute also hosted an event on European defense integration after the re-election of Donald Trump with Sylvie Goulard, the former Defense Minister of France. And on that occasion, we also launched a new project called Alcide, which stands for Activating the Law Creatively to Integrate Defense in Europe. And I'm very pleased to announce that a policy paper has just been released 2 weeks ago at the time of the Munich Security Conference, where we are proposing some concrete steps to integrate defense in Europe and face the Russian threat. And I'm glad to say this is already having an impact in the policy discussion. What I'm also proud to say is that both the Brexit Institute and Delhi have produced numerous academic and policy analysis on the war in Ukraine, including several blogs, multiple working papers, a book, the one that Andrew co-authored, and I myself published a book earlier this week entitled The EU Constitution in Time of War, Legal Responses to Russia's Aggression Against Ukraine, with Oxford University Press. So this is a stream that is very much at the heart of the work we do here. In light of all this, I think it's only fitting that we are hosting a conference this year to mark the third anniversary. And I wish to thank the university, the whole team of the Institute, especially Charlie Halford, and especially the Department of Foreign Affairs for co-sponsoring this with us this initiative. We're really pleased to be partnering with the DFA. Of course, this event, let's be honest, comes at a uniquely difficult moment, given the 180 degrees policy turn that the new American administration under Donald Trump has impressed on the process. And I think here the beginning of bilateral negotiation between the United States and Russia without involving Ukraine, without involving Europe, is really creates major uncertainty about the future of the war, the prospect of accountability, and the search for justice in Ukraine. At the same time, I'm also very pleased that the focus of this year event has been primarily on the Council of Europe, which is an organization, of course, separate from the European Union, and an organization that has played and keeps playing a key role in the European continent for the protection and promotion of human rights, democracy, and the rule of law. And for this very reason, I am really genuinely delighted to be able to welcome here at DCU Professor Michael O'Flaherty, who since last January serves as the European Commissioner for Human Rights. I should really say Michael is Ireland's favorite son, so I don't need to introduce him. I shouldn't be introducing him in detail, but because I'm sure all of you in this room know him well. But let me just say that, of course, before being elected by the Parliamentary Assembly of the Council of Europe for his post, which is a 6-year non-renewable mandate, Michael had multiple responsibilities in other roles. In particular, from 2015 to 2023, he was the director of the EU Fundamental Rights Agency based in Vienna. Previously, he was also a member of the United Nations Human Rights Committee from 2004 to 2012, and among others, the Chief Commissioner of the Northern Ireland Human Rights Commission from 2011 to 2013. Moreover, as an academic myself, I am pleased to emphasize that besides his stellar career in public service, Michael is also a scholar. He held previously professorships of human rights at the University of Nottingham in the UK, and of course here in Ireland at the University of Galway. And he has been a prolific scholar and author in the field of human rights. So he personifies the dream of the speakers we'd like to have at Delhi: public service and great scholarship all at once. So without further ado, I'll stop here and hand the floor to Michael, who has also accepted to take question and answers after his speech. Once again, welcome to DCU Garamila Mahi.
Good afternoon. Thank you for that very warm introduction. Thank you and well done to DCU for the event. I join all those who are so impressed by everything we saw and heard this morning. Well done to you, Andrew, for conceiving of the whole event. And I have to tell those of you who know Andrew maybe not so well that it's frankly impossible to say no to his invitations. So it's a great delight to be here. I consider what's been going on here today a very honourable exception. A very honourable exception in that there is a focus on people, on justice, on human well-being, on human rights throughout the discussions today. That is honourable, but sadly it's also exceptional. You do not see that focus of attention in many other places where it needs to be. There's no mention of human beings whatsoever in what I'm following in the media from the current US initiatives. It's about property, it's about land. There's no reference to the people who live on that land or who have been displaced from that land. Earlier this week with my colleagues, we did a review of what the big influential US think tanks are saying about Ukraine. And we quite deliberately went to those that lean towards Democrats and those that lean towards Republicans. We found nothing. Nothing about the specific issues of honoring human dignity in the context of building a peace. I'd have to say that references to human rights are also somewhat limited in other places where one looks for ideas and hope in this context. The 10-point Zelensky peace plan does make reference to human rights, but it's not a very drilled down and deep reference. The very important Bergenstock summit of last year in Switzerland, again, only glancingly refers, I would say, to issues of human rights. And then when you get to the operative paragraphs of the UN resolutions adopted this week, again here, little attention. Particularly in the General Assembly resolution, there's a lot of rhetorical reference in the preambular paragraphs, but it becomes rather scant moving through the document. This absence of attention to human rights outside this room, admittedly, nevertheless forces me or makes it, I think, very important that I restate now a few basics. The first basic has to do with the scale of the human rights abuse and that we're witnessing. We can dispute the numbers, but according to the UN, over 12,000 civilians dead, of whom 650 were children. and so many countless military deaths in addition. 700 medical facilities and 1,500 schools damaged or destroyed. Summary executions, escalating rates of summary executions by Russian forces, who also, according to reports, are systematically torturing prisoners. A country, Ukraine, that is now literally littered with unexploded ordnance, with all the consequences for years to come. And in the occupied territories, a despotic regime in operation. That's the first issue that needs to be restated. The second fact that needs to be restated has to do with the perpetrator. There's without any shadow of doubt that the vast majority of the human rights abuses and violations, the responsibility lies at the door of the Russian aggressor. Third, what kind of human rights abuses and violations are taking place? All kinds. It's as much about the violation of economic, social, and cultural rights as it is civil and political rights. Just look at the attacks on infrastructure and the deliberately inflicted environmental disasters and the impact they have for every imaginable human right. Fourth of my cluster of facts has to do with the need for a persistent and full engagement with the situation in Ukraine on the part of regional and international human rights machineries. I consider that the Council of Europe, frankly, could do a better job in terms of drawing its full machinery to bear with regard to Ukraine. Some of the treaty oversight bodies have, to my mind, insufficiently engaged the urgency of the lived experience of the country. In my own mandate, I have to maintain a high focus. I do consider that the situation of Ukraine is my top priority, but I hope that I will honor that in what I do. And that is the context for the fact that I will visit Ukraine within the next couple of weeks. It'll be my second visit since I took up the mandate. Staying with the international mechanisms, but moving beyond the Council of Europe, it's important to acknowledge the vital role that's being played by the United Nations in terms of monitoring. The United Nations has become the primary source in terms of reliable information on what is happening on the ground. And I want to express my deep appreciation for the work of the UN Monitoring Mission and the UN Commission of Inquiry, a job that is made all the harder, but nevertheless continues to be delivered, notwithstanding the refusal of Russian forces to give access to the monitors. Before I move off monitoring, let me briefly engage the issue of why bother to monitor. I sometimes, particularly in the middle of a conflict, am challenged as to why we invest so much effort, attempt to put so much focus on human rights monitoring. Well, I've been in this work my whole life. I started in Bosnia-Herzegovina way back in the early 1990s, and in conflict after conflict in Bosnia and subsequently, I've seen the critical role that an investment in monitoring plays. It plays, or at least it should be able to play, an important role in informing the immediate engagement with the situation and in terms of categories with which to interpret and to understand the immediate situation. It, again, to follow on this morning's discussion, plays a very important role towards eventual criminal justice. And third, and no less importantly than the previous two, it does, or it should, orient the path to peace. Now, it's the orientation of the path to peace that is my big preoccupation right now, and it'll be very much the subject of my attention when I'm in Ukraine in my upcoming visit. There's vast global good practice in terms of the role of human rights, a human rights focus in orienting any path to peace. And let me suggest three elements of the human rights roadmap, if you will, towards a just, a fair, and a lasting, effective peace. The first is the one we discussed this morning, so I don't have much to say about it. It's about ensuring accountability, including criminal accountability. It is about supporting the International Criminal Court, moving towards the establishment of the Tribunal on Aggression. But, and this wasn't so much discussed this morning, but no less important, it's about building up the national capacity to do criminal justice. Whatever happens, the vast majority of criminal processes towards justice will be at the national level. To the extent people are tried for their crimes, it'll happen in Ukraine. And so we should already now be intensifying our own engagement with that country to see how we can support its capacity to do human rights compliant investigation, prosecution, and trials. We also have to look at the prison capacity as well, in terms of the assumption that people will be held accountable, will go to jail. The second dimension, again, it received plenty of attention this morning, so not much from me now, has to do with the delivery of redress and restitution. And so I very much welcome, and indeed I'm proud to be associated with the organisation that took the lead on such initiatives as the Register of Damages, towards a claims commission, and so forth. But moving beyond the topics of this morning's discussion and to the third of my 10 key pointers for a human rights compliant peace, we have to remember that Ukraine is going to need a lot of help and support as it transitions out of martial law. It's not a comment specific to Ukraine. It happens everywhere you have martial law, but something of the democratic culture diminishes in a period of martial law. And so Ukraine deserves our support as it shakes off the restraints that come with the martial law environment. And we also have to think of the challenges that will be faced to the extent that Ukraine reclaims occupied territories in establishing the democratic and the human rights respectful cultural dimension of the society there as well. Fourth of my 10 has to do with speculation. I have no insider track whatsoever, but the speculation as to whether some territory may, at least de facto, not be immediately restituted to control of the authorities. And here, as I say, I'm purely in a speculative space. But to the extent that we will have such a situation, we have to look at how human rights get respected in such territories. And we'll be looking to people like Andrew for guidance there, because, of course, this is your well-known specialism of your research. But it is a dimension that we must not forget. Fifth, we're going to have some very important movement of peoples, which will need to be done in a manner that pays attention and shows due respect for human rights. There is, above all, the return of IDPs and refugees, raising highly complex issues. Ukraine, as is maybe not well enough known, is having some difficulty in welcoming is the wrong word, in delivering the supports needed for IDPs who have moved from the east to the west of the country. Those issues will not disappear overnight. And then there are a vast bundle of questions around the return of people to Ukraine. Seventh of my I beg your pardon. Sixth of my 10 points has to do with the release of prisoners. We're going to have some very complex issues to navigate, again, in respect for human rights, in terms of release of prisoners held on all sides, including those who may have been relocated to Russia. And here I keep in mind as well, while not necessarily prisoners, the children, the unknown number of children who have been relocated to Russia in a context where it's very difficult even to get the basic statistics as to who they are, the data as to who they are. And one final dimension I'll mention here in the context of return has to do with tracing of the missing. There are very, very many people missing, disappeared. And again, a human rights respectful engagement with that issue is imperative. Seventh of my 10 points relates to the need to reconstruct a deeply damaged country, a physically deeply damaged country. There is need right now, frankly, for a humanitarian engagement that will continue into the near future, and that will transition into a more developmental phase. And we need human rights like a golden thread running through all such efforts, whoever undertakes them. Eighth is a very interesting and perhaps unique question with regard to Ukraine. If it has happened before, it would be good to have it pointed out to me. But I cannot think of another situation where there will be the interplay of the EU accession pathway and a peace process. And of course, I'm looking at that from the particular point of view of human rights. The EU accession pathway will carry with it human rights obligations. The state must deliver on A, B, and C, X, Y, Z as part of the pathway. I want to see a peace outcome that will similarly have commitments to human rights. And we'll have to navigate with care, and I believe with great novelty, I don't think it's been tried before, the interplay of these two forces for the society. Ninth of my 10 points has to do with that picture we all saw last week from Riyadh, from the first meeting of the Russians and the United States representatives. The telling thing about the picture was that it was all men. There wasn't a woman in the room. And I thought, as I looked at that picture, what about Resolution 1325? What about the vast key of experience in appreciating that you don't have a good peace process without women in the peace process, if they're not at the table in every imaginable way? And the evidence is there. UN Women, for instance, has published study after study showing that if women are directly engaged in the process, you will have better outcomes. And so it is desperately important that women engage within the context of whatever peace process we're referring to. And 10th and finally, excuse me, I stay with the issue of actors. Which actors should be in the room? We're looking on now with some bemusement as to what on earth is happening, but we see a very limited range of actors. And I'm concerned that we draw from the well-established, over decades now, international good practice. It's about having women in the room, but it's also, obviously, it's so obvious it doesn't need saying, it needs the Ukrainians sitting at the top of the table. But it also needs Ukrainian civil society in the room. I've participated in a number of peace negotiations, and I've seen how it was the engagement of civil society that got issues onto the table that would otherwise have been entirely overlooked. We need the Ukrainian National Human Rights Institution in the room. Dmitry Lubinets, the ombudsman, he needs to be there, bringing his unique voice to whatever discussions take place. And of course, we need the relevant representation of the relevant regional and international human rights bodies. And that brings me to an observation about actors, and that is the role of a multilateral organization and the extent to which peace will embed better, will emerge better, to the extent that it is developed in a multilateral context. For reasons we don't obviously need to explore this afternoon, it's unlikely the United Nations will ever be able to play that role. It's doing fantastic work on the ground, but at that bigger political context, it doesn't look like it's going to play the role. And that's unfortunate for many reasons, but one of them is that it means that the human rights dimensions will not come almost automatically into the room. Again, I sat through a number of processes on behalf of the United Nations. I did not have to push hard to, at least at a minimum, have a certain element of the agenda put on the table because of the commitment of the United Nations institutionally to the promotion of human rights. Absent such a multilateral role or engagement with regard to Ukraine, I worry. And here, of course, I come back to the organization with which I'm now affiliated, the Council of Europe. It is playing a stellar role in terms of criminal accountability and the award of claims and related matters. But I wonder, is there a bigger role beyond the existing functions, beyond the existing mechanisms of the institution? Is there some role, a gathering space within which this broad array of human rights issues I've referred to could be given more visibility and more light? That's something, certainly an idea I will be taking back to Strasbourg with me, but I'm still rather naive and new to the institution, and I'll see where we can go with it. Last point I'd like to make, still staying with human rights, has to do not with the human rights of Ukrainians, but all our human rights. The impact that the Russian aggression has for all of us and for all of our human rights. And here again, I'm concerned. I'm concerned at the extent to which it has triggered a diminution in respect for human rights in parts of other countries. I think of the securitization of European borders. I think of the 3 cases in which I made interventions at the European Court of Human Rights last week regarding so-called pushbacks at the Belarusian border. These are all connected to the story of the Russian aggression against Ukraine, and they are they are creating a space within which there's a growing rhetoric in EU member states, for example, to push back on solemn human rights commitments, such as honouring the principle of non-refoulement and the avoidance of summary returns. A second human rights dimension impacting all of us is the flood of disinformation and the spread of hate that's infecting our social medias just as much as the social medias of those people directly under attack. I encountered this personally recently when it was brought to my attention and I was shown a deep fake video of me in which I was saying some deeply inappropriate things, deeply unhelpful things. It's not me, it's not my voice, but it looks like me, it sounds like me. And it was a reminder, just a tiny single person anecdotal reminder of the extent to which our space is being polluted in a way that compromises human rights in the light of the aggression. Third, you can read a lot of this morning's discussion as implicitly about the damaging impact of the conflict on our institutions. The jury was out this morning on the extent to which the Council of Europe was damaged by the experience of the expulsion of Russia. I'll say no more than that, but at a minimum, question marks are put over our institutions. And indeed, of course, I've made reference just now to the absence of the United Nations from the table, which is, I think, also damaging. And then finally, in terms of the human rights impact beyond the borders of Ukraine, there is the existential threat to every one of us and every one of our societies if Russia were to succeed. The war is a war on values. It's a war on the fabric we've so carefully constructed since the Second World War. If Russia either wins or is perceived to win in its aggression, then our Europe will have been very badly damaged indeed. And that is the context in which, for my very last remark, I want to express my deepest respect and to acknowledge our profound debt to Ukraine. There's talk at the moment of Ukraine paying for security, of paying for the intervention to help it overcome the aggressor. I find that deeply disturbing. Ukraine owes us nothing. We owe Ukraine an undying debt of gratitude for being the ones willing to stand up to the tyrant. Thank you.
Michael, for those wonderful remarks. Commissioner O'Flaherty has agreed to do a little Q&A session. We're very fortunate to be able to engage directly with him. So I'm opening the floor. Please raise your hand and quickly introduce yourself if there are questions. The gentleman at the back, I think a mic is on its way.
Commissioner Flaherty, I'm very struck by your point 8.
If you could just introduce yourself very quickly.
Donald O'Brien, I'm just a citizen, I'm not a lawyer. So I'm very struck by your point 8, where you talked about the peace process in Ukraine and EU accession. As far as I'm concerned, the European project, which started with the Council of Europe, is a peace process with a common market, central bank, common trade policy and all the rest of it attached. So the key process is the peace process that is still there, arising from conflicts in the 80 years before 1948 between France and Germany, basically. And so I think that, you know, I don't see that there's any, I'll use the word big basic issue between EU accession and by Ukraine and the peace process. What have I misunderstood?
Nothing, because I agree with you. I wasn't raising it as a problem. I was raising it as an issue, which is unique. And will inevitably, as a result, influence the shape of whatever outcomes we'll have. In fact, I can see many advantages to it because the accession pathway could be a driver for changes that, if left exclusively to a peace negotiation, it might be more sluggishly implemented. So no, if you heard me suggesting it was a problem, not at all. But we do need to engage it because it's something we haven't had to deal with in the past. It also changes the identity of the actors in the room. So DG NEAR suddenly becomes part of a peace process in a way that nobody in DG NEAR would ever have imagined in another life.
Constantine.
Thanks very much. Thank you for your presentation. Being originally from Belarus, I was interested in your remarks about recent pushback cases. And you, as far as I understood you, if I understood you correctly, you connect these pushbacks to the war in Ukraine. Can you elaborate a little bit on that? Like, what is the connection that is there? Because I thought that pushback started before the war and connected to the rigged election in Belarus in 2020, and the fact that nobody really cared about that except Russians, really. Thanks.
I think there's a clear link between what's going on in Ukraine and the current problems we're seeing at a number of borders, in that there's a huge concern in those bordering states of Russia as an aggressor. As in, if they're doing this in Ukraine, what could they do on our border now or next? And it's in that context that the walls are being erected, the doors are being locked, and those who manage to get through those doors are or at least could be sent back. That's what I see as the connection. Yes, we've had so-called instrumentalized abuse of migrants at borders for years, but also indeed there has been an intensification of it since the conflict in Ukraine began, at least with regard to the Belarusian border.
I think Andrea has a question there too.
Yeah.
Gentleman then. Sorry. Andrew is waiving his right to speak then.
You've been talking, Michael, about the necessity to bring human rights back into the situation caused by the war and so on. And that's very important, obviously. But I wonder, what you feel about me saying that it's also necessary for the Council of Europe, if they are working to protect human rights as a result of the Ukrainian war, that it's difficult to combine that with the attitude that has been taken by a lot of the members of the Council of Europe towards what's going on in Gaza, where clearly human rights have been totally disregarded and there's massive murders of innocent people and so on, and that in order to have the, how would you put it, the right to argue for human rights to be resumed in various other, in the issue of the war with and the Russians, and what has happened within Ukraine as a result of the war. But there is a difficulty if you're the people arguing for this and are not also saying that human rights must be defended in other areas, and in one which, while it's not a member of the Council of Europe, where a lot of the states in Council of Europe are supporting what has been done or refusing to condemn what has been done in Gaza.
Thanks, Michael. It's a fair point, but double standards must not be allowed freeze us into inaction, and we don't have a right to engage on human rights in Ukraine or elsewhere. We have a duty. Our institutions have a duty. So notwithstanding the double standards that we see in many settings and in many contexts, that duty is in no way diminished and must be engaged. Let the unpleasant and in some contexts unacceptable politics, let's engage them as that, but without allowing that to interfere with the responsibility to stand up for the human rights of people on territory of Council of Europe member states. I'm not sure if I'm still engaging your question, but I'm constantly challenged on this. I'm asked, why are you, how dare you speak about Ukraine? You say nothing about Gaza. And I tell them my honestly held view that what goes on the territory of Gaza is outside my mandate. Because if it's Gaza, then it's South Sudan, it's DRC, it's Myanmar. There's no end to it. And yet I understand that my role is with regard to standing up for the human rights of the people of the Council of Europe member states. Now, I don't know if I'm helping in response to your question there, but indeed, and let my last remark be that we are losing the street. Many people on our streets will make the point you've just made, that we have lost our authority, we've lost our credibility because of what you've just described. This is an enormous concern, but I believe it's one outside the remit of what we should actually do in terms of honouring our duty.
This was a jurisdictional answer to some extent, and rightly so. I think Ed also raised his hand.
Yes, thanks. Ed Bates, University of Leicester. Thank you very much for that. It's really looking over the horizon to me, and it's very powerful. And I was struck by the long list in the sense that there's so many things. And to the extent many of those issues may be to some extent on your desk, not all of them, of course, but I'm wondering whether, do you have the capacity in your office and around, the resources? Maybe you could comment on that. Nobody could fail to be struck by the importance of the areas you just covered. So how does one look, therefore, to marshal resources? Does one imagine the Committee of Ministers to sort of pass or create particular documents relating to this that will garner that support? I wonder how kind of some of the material side of this can be realised. Thank you.
Michael, if you don't mind, I'll collect, because we're a bit short on time. So there's two more questions. The gentleman up there, and then Pedro at the back. That's fine. We'll collect the two more and then give you the final words.
Remember all three.
Thank you, Commissioner. Caleb Kyle, Stanstone. I was interested in your comments about human rights running as a golden thread through the reconstruction. And clearly looking forward, there will be a lot of reconstruction. I welcome your comments on a couple of points on how that might look going forward.
And we'll collect the last question at the back from Pedro, PhD student at DCU.
Hello. Would like to briefly come back to the pushback cases issue that you raised before. And well, in these cases, the respondent states, which are Latvia and Lithuania and Poland, are basically arguing that because Belarus will instrumentalize migrants from third countries against, like, to undermine their public security, they had a right to, well, water down procedural safeguards related to the principle of non-refoulement. And I would like to hear, like, what do you think about that, and especially what would be the consequences for the consistency of the convention if these arguments were to be accepted by the court. Thank you.
Thank you. Let me try and respond to all three. First, the capacity issue. Well, the capacity will never come from me or from my office. It's tiny. I have a staff of 15 human rights specialists in a total of 30 people. I have no operational capacity, and if I were ever asked to take on an operational function, I would have to decline it because of that. What's more, indeed, the mandate was never designed to be operational. My role is essentially to be a diplomatic nuisance, to use my voice as creatively and as effectively as I possibly can to prompt others to act. This happens to be the first platform I've used to make the remarks I've just made today, but it's the first. I intend to make these remarks persistently, and let's see if I have any capacity to engage those with the necessary capacity to do the job, be they in the Council of Europe or elsewhere. Turning to the golden thread, we've learned an awful lot over the last 20, 25 years in terms of how to embed human rights at the heart of humanitarian engagement and, let's call it, development work, because it's tended to define itself and take on its shape in a developmental rather than a reconstruction context. What does it mean? It means that the international human rights treaties are the normative base for the engagement. They help you, in a sense, set out where your priority attention should go. It's always going to be about people in the first instance, and it's going to be indeed about the most vulnerable people first.
So whereas it's conceivable a reconstruction program could be so focused on an economic analysis that it forgets the human beings. So that's a quality that human rights brings. It also brings a non-discriminatory element, so that if groups are treated separately in the reconstruction efforts, that there's a legitimate justification for that separate treatment, not an illegitimate discriminatory basis, such as preferring the rights of settled people over non-Roma over the very large Roma population of Ukraine. That's a speculative example. It's not an observation on any set of facts. It's very difficult to run this golden thread, by the way. You will constantly come up against resistances. One resistance has to do with the fact that a human rights-based approach, this golden thread, involves a high degree of participation of citizens, of rights holders, in the reflection about what is needed, where, when, and how. And many planners find this irritating because it slows everything down and maybe ends up with outcomes in a different order to the ones originally intended, but nevertheless leads ultimately to more trustworthy outcomes. So they're just some illustrations. And then quite separate to the conflict and quite separate to the fears, the legitimate fears on the part of states neighboring Russia and Belarus, which I don't diminish at all. There are fundamental human rights principles at stake, which, if lost, would, I think, have very damaging consequences for the entire construction of human rights. Non-refoulement is one of the most precious rights we have in the entire acquis of human rights refugee law. It's the basis on which so much else flows. I remember many years ago in Peshawar in northwest Pakistan, meeting with a bunch of Afghan men. They were in exile at the time. Taliban were still in power, first Taliban, if we can call it that. So in Peshawar, they were gathered, and this was a bunch of leaders among the Afghan community, all men, all old men. And for some reason, I found myself having to talk to them about the right of asylum. I was stopped through translation, obviously, by one old gentleman who said, "You don't need to tell us about the right to asylum. The Prophet taught us that." That's illustrative of how deep this is as a core norm around which everything else is constructed. And I believe if we whittle away at these foundations of the system, we make the entire system less secure. And I worry then about its future.
Thank you very much, Michael, for those words. I think this is a high note on which we can probably end this session. I would like the public to join me in warmly thanking Professor Michael Flaherty, the European Commissioner for Human Rights, for joining us today.
Very much.
So in the interest of time, without further ado, I'll ask the panelists of the final panel of this conference to join me here on stage or indeed online. We are beginning with a little bit of delay, but I'm very pleased to be chairing also this panel entitled Securing Peace and Justice in Ukraine in a Divided World. This is I'm proud to say, all-female panel, which features three excellent speakers, one in person here in Dublin and two online on a screen behind me. Joining us from Ukraine, indeed. So I'll begin by introducing them, starting with the lady sitting at my left, my dear colleague, Dr. Tanya Lokot, who is Associate Professor in Digital Media and Society at the School of Communication here at Dublin City University. Tanya has been researching protest and mobilization, threats to digital rights, network citizenship, internet freedom, and indeed internet governance in Eastern Ukraine. She has published extensively in some of the top journals in the field. She was involved also, I believe, in a major Horizon Europe project that has just come to an end. And she has also been a long-standing friend of the DCU Brexit Institute and Delhi. A year ago, she spoke together with my colleague, Ken McDonough, at the second anniversary of the war in Ukraine. So we're delighted to have you back, Tanya, with us today. Then also on the panel is Svetlana Starozovit, who is an American Society of International Law Fellow. Svetlana recently graduated from Harvard Law School, the PhD JSG program, and she previously worked for the Ministry of Foreign Affairs of Ukraine, counseling the ministry on legal strategy for holding Russia accountable before international courts. Svetlana has been an expert on international nuclear law for many years, including, and she was involved in a number of FSIA cases on Foreign Sovereign Immunity Act in the United States as well. And then last but not least, also in the panel is Zena Kozliova, who is the legal director of the NGO Truth House. She has a law degree from Ukraine, and she worked for the Ukrainian Helsinki Human Rights Union, as well as the Ukrainian Bar Association as an expert in training. She's also a Crimean Tatar, and therefore has been personally affected, of course, by the war since 2014. So not just the latest, largest invasion, but of course the beginning of the war. The panel will run for about 45 minutes. So I think without further ado, I'll probably begin by simply following the list on the program, which I think puts Zera as the first speaker. So Zera, I hope you are there and you can listen me and see us. The floor is yours, and thanks for joining us.
Yes, thank you. Do you hear me well?
Yes, we can hear you.
Thank you. Thank you very much. And good afternoon for all of you, our colleagues and dear conference participants. It's a really great honor and pleasure for me to participate in today's event. And really and sincerely thank you for the invitation and for your interest in Ukraine, as well as for your continuous support during this war. We really feel it also. I firmly believe that our joint efforts will lead us to the necessary outcome, namely ensuring justice and peace. I want to say just a couple of words about our organization and myself, and maybe it explains why my focus on the main issues of fair trial, of justice, and of accountability of war crimes. Currently, I represent the organization Truth House, as you say, and since 2014, Truth House has been documenting international crimes. Prior to that, from 2014 to 2023, during 9 years, I worked in the prosecutor's office in the same field. And also, as you say, one of the reasons for my work in this area is that I'm a native Crimean. And today I can serve both as a voice of human rights advocacy and of those who have suffered from the armed conflict and have a great demand for justice. And before 2022, Truth Hounds operated not only in Ukraine, but also in other countries. But after February 24, the number of war crimes and other international crimes in Ukraine reached such levels that our and other non-governmental organizations focused all their efforts on documenting these facts and supporting national investigation. And as for today, maybe you know, just the official number of registered international crimes exceed more than 157,000. Understanding these challenges faced by national justice system, we have been building cases that reflect the systematic nature of crimes and specific patterns in their commission, consolidating numerous of these episodes. This work demonstrates that most serious violations of international humanitarian law and gross human rights violations are not isolated incident, but part of Russia's systematic policy. Examples include the torture of civilians and prisoners of war, the illegal deportation of children, and the practice of double strikes on civilian infrastructure, where and when a second attack is carried out shortly after the first, specifically targeting medical and emergency response teams. And another example is the consistent use of guided aerial bombs in densely populated urban areas. There are just a few examples. And as someone who has been monitoring Russia's methods and means of warfare since 2014, I can confidentially state that no concessions in negotiations with Russia have ever stopped this violation. For instance, the lack of consequences of Russia after the occupation of Crimea led to the war in Donbass. The actions in eastern Ukraine, which also didn't result in significant consequences or sanction, eventually led to the full-scale invasion. The absence of accountability for crimes in occupied Crimea and eastern Ukraine has resulted in tens of thousands of crimes after February 2022. And now I say just about events in Ukraine and violations in Ukraine, not in other countries where Russian soldiers also committed many of atrocity crimes. This demonstrates that impunity leads to more serious numbers crimes. This is not a complaint or grievance, but rather a call to action. Despite today's turbulent global events, or perhaps because of them, unity and support for justice and peace are more crucial than ever. And all of us understand these conditions. And for us, more than somewhere, so important supporting by the countries and from the countries who are member of the Council of Europe. And for us and for our opinion, investigations and accountability for the most serious crimes are only one element of transitional justice, but in the current context, other elements such as the right to truth, the preservation of historical memory, the memorialization of victims, and compensation for material and moral damage are becoming increasingly relevant. And but the very important point that this effective investigation and fair justice can and should serve as a solid foundation for this. Even we have some risk for really ensuring really accountability of crimes, but it can be very good basis for other elements of transitional justice. And I am sure that our country needs these elements because of how we can see that when we wouldn't realize some elements of it, how it was after in post-Soviet Union time, it can have very bad consequences for development of democracy values, and we need to think about how to work with our historical events. And this is effective investigation, as I say, and fair justice can be served this. Our organization places significant emphasis on collecting and properly documenting information about crimes through victim and survivors' testimonies, as well as digital evidence, and the documentation and preservation of all data will help ensure the retention of evidence for years to come and prevent the truth from being forgotten. This is one of the key tasks currently faced by actors addressing war-related issues. Today, the justice architecture for war crimes in Ukraine includes three main parts of this system. The first one is national level. The second one, cases in the International Criminal Court, and the third is universal jurisdiction, under which more than 23 countries have opened their own investigation. And from our opinion, in these issues, in supporting all of these three levels of accountability system of atrocity crimes in Ukraine, in these issues, members of Council of Europe can be key actors for today. And it's very important to continue supporting capacity building of national agencies, because the most of crimes investigate in Ukraine and here, and also are going on Ukrainians here in Ukrainian court, I mean. And also all types of supporting of ICC, it's also very important to ensure an accountability of these crimes, especially in the today's context. Yes. And what about universal jurisdictions? It also very important cases now in different countries, and our call to action to continue this investigation and to support this investigation. And the main message is not to stop, but to continue supporting all three levels of this system. We must enable the collection and documentation of reliable factual data while remaining committed to the principles of the rule of law and human rights. This will always serve as an additional advantage in any discussion about the future of Ukraine and Europe, as well as reaffirm commitment to international justice. This is one of the core values for which Ukraine is fighting on the battlefield today. And we really believe in accountability, and really believe that it's important for stopping this violation in future, not only in Ukraine. So this is my general points, and thank you for your attention. I would be happy to answer any specific and detailed questions you may have during discussion about some types of investigation or something else. So thank you for your attention. I really appreciate it. Thank you.
Thank you very much, Zara. I don't know if you can hear the round of applause here, but there were claps. So thanks for your remarks. I'll come back here in the room actually and hand the floor to my colleague Tanya Lockott, who is not a legal scholar, but she's a scholar of communication. And I think that makes this panel even more interesting because we are combining in an interdisciplinary perspective multiple takes. I'll hand you this microphone. Thank you, Tanya.
That's perfect. Thank you, Federico. And I'm very grateful to Zara for her remarks. I think they really set the tone for this conversation. And of course, very grateful to Andrew and the Dublin European Law Institute for convening such a profound set of discussions, speakers, remarks on this very important issue. As Federico said, I'm not a legal scholar, but I think it's really interesting to use this unique opportunity where you have not one, but three Ukrainian female academics and practitioners on a single panel. One of my Ukrainian friends likes to refer to us who go and speak in public fora about the impact of Russia's invasion on Ukraine as Ukrainian killjoys, because every time we enter a room where there's fun conversations happening, everybody goes quiet and they're like, oh, they're here to talk about the war again. But I think, I feel justified, especially because this whole day has been nothing but killjoy conversations with the hope that, the outcome that we're all working to achieve might be slightly more hopeful. So in that sense, I would like to focus on the broader conversation about where we get knowledge about what is happening in Ukraine and the impact that Russian aggression has and has had on the Ukrainian population, but also on the broader conversation about how we know what to do in terms of achieving sustainable peace, accountability, and justice for Ukraine in a more global sense. When we think about how the world comes to know about the war Russia is waging in Ukraine and its impacts, we of course think about the role that the media play, but also the role that high-level conversations and these global fora, be it the Council of Europe or the UN Human Rights Council, take place. However, we are also faced with a situation of an increasingly digitized global environment where power is also contested and authority contested in not just offline spaces and high-level diplomatic fora, but also online spaces, including the pages of the media and social media feeds, which can be quite chaotic, but can also be quite revealing when we're looking for information and knowledge about what is happening. It's fair to say that this war has been globally visible, but it's also been legible to different people in different ways. And in no small part, we talk about the war in Ukraine being the most digitally mediated war because Ukrainians themselves at every level have been making their participation in war their history and the context around the war, but also their resistance to Russian aggression and the way it has impacted them, very visible, very legible, and very knowable. The information is there if you want to find it, but the question is, how do we perceive this information and what do we do with it once it's out there? The effort, I think, of Ukrainian civil society, the media, the diplomats, the Ukrainian officials, has been to contest this prevailing so-called stale view of Ukraine that much of the world, and especially the Western world, has had in the context of the dominant ideas put forth by the epistemic imperialism of all the experts, Western scholars, politicians, but also Russian imperialist narratives, which colleagues have said have had a lot of power and have had a very powerful hold on how conversations about who is to blame, who is the victim, who is the perpetrator have been framed. And part of the challenge for all of those working to attain justice and to prevent further human rights violations, especially when these remarks and these points and arguments come from the Ukrainian side, is that as Ukrainians, people view us in a certain way, but we also kind of have this sense of epistemic injustice because since we're so close to the action, are we to be considered a reliable narrator? After all, we have a huge stake, right, in what is happening, partly because it is happening to us, to our families, to our homes. And I think it's very important to not let go this idea that part of ensuring justice for Ukraine, part of ensuring sustainable peace and accountability is also achieved through validating that embodied knowledge and the lived experiences of the very people affected by the war, to not see them as biased because that's the knee-jerk reflex, but to actually be able to listen and take into account what these people are telling you because they have actually lived through these experiences. And I'm very grateful to Professor Flaherty for mentioning the fact that keeping the focus on human beings and human dignity is actually an honorable thing to do in this case. And my colleague, Katerina Busol, earlier also made a point in her remarks to focus on centering the victims of Russian aggression. But I think this speaks to this broader need to really reckon with the embodied reality of war and not just think of it as headlines or political games or diplomatic tit for tat. Actually understanding that embodied knowledge, understanding how it feels to be in the middle of being targeted by a powerful aggressor state, illuminates the war itself not just as a political process or a military confrontation, but as a bodily experience. And recognizing, validating personal emotional experiences helps us as human rights defenders, as lawyers, as academics, to center ordinary bodies as vessels of knowledge, right? Because these are the bodies that are suffering, and these are the bodies that are looking for justice, for peace, and for reparations. So civilians and civil society, media workers have all been targets of Russian aggression in Ukraine. Thousands of men, women, and children have been killed, taken hostage, are missing, have been deported, imprisoned, and tortured by Russian occupying forces. Civil society, human rights activists, and volunteers specifically have also been targeted because they're the ones who not only hold bodily knowledge, but also collect that knowledge from others, as Sarah just outlined. According to the Zmina Human Rights Foundation, the Ukrainian human rights organization, at the end of 2024, at least 121 activists, volunteers, human rights defenders, and journalists are known to have been killed as a result of their work in Russia's full-scale aggression against Ukraine. So some of these people have been targeted specifically because of the work they do to to ensure justice and achieve sustainable peace. I'd like to offer you a brief quote from Maxim Butkevich, who is a very well-known Ukrainian human rights activist who volunteered to serve on the front lines before scale invasion started, and who ended up being captured by Russian forces and spent over 2 years as a prisoner of war in Russian captivity, where he was tortured and prosecuted explicitly because he was also a human rights activist. He gave an interview to the Irish Times just recently, on the 25th of February. He said, he talked about his experiences, and he said, I felt I should go through this to experience it firsthand, so I could talk about breaches of human rights and what the Russians are doing to Ukrainian prisoners of war and civilians, not just as an observer, but as someone who is going through it. So I think it's important to foreground the citizen experiences of war, because we need to see people not just as victims or as objects of justice and reparations, but as agents who are producing knowledge about the war that can be useful, right? We need to establish the agency of individuals for self-determination, central to Ukraine's civic ethos and identity, central to the European values of individual freedom, responsibility, dignity. But we also need to work on reconciling the admissibility of evidence and testimonies of war crimes in courts with the importance of documenting people's lived experiences and stories as its own form of agency. I think the work that organizations such as Truth Hounds or Clean Foundation for Justice or the Zmini Center for Human Rights and many others do underscores the importance of this. We also need to make sure we train journalists, researchers, human rights workers, and volunteers in responsible trauma-informed interviewing and reporting, because we want to collect the evidence to ensure that justice is done. We also don't want to re-traumatize the victims of this injustice when we do so. We also need to be constantly examining the ethics of data collection analysis using open source intelligence tools and social media content that may be public by default, and how it makes its way into the materials that go before the courts to ensure justice. And finally, I think an event such as today is very important because we also need to be platforming discussions on knowledge production about the war and how we seek justice using that knowledge. And we ask the questions, who should be able to speak loudly about the war and who maybe should remain silent, at least for a while, so that they can listen and learn. So in here from the Council of Europe, the European Court of Human Rights, to more global, such as the UN Human Rights Council, all of these important intergovernmental and regional platforms, we should start to problematize patterns of knowledge production and sources of expertise in conflict resolution, diplomacy, peacemaking, and transnational justice. We should also, I think, seek to decenter that West-splaining that we're all so fond of slagging in personal conversations, and those imperial perspectives and post-colonial perspectives of peace, justice, and accountability processes, because it's only by decentering the dominant models that we can imagine that these processes could perhaps work differently. And we've heard some brilliant ideas here today. I think it's also worth centering these underrepresented grassroots and community voices to understand how they have lived these experiences, and to understand that everybody's experience of war or conflict is different. But just because it's different doesn't mean it's not worth capturing, whether it's experiencing the war or displacement or trauma and recovery. So building on these bottom-up dynamics to enact broader reform, thinking global mechanisms for post-war justice will be helpful not just for Ukraine, but also for the rest of the world and for every other area which is ridden by conflict, because we do need to understand how to make war crimes prosecution, reconstruction, and reparations actually possible, but also just and sustainable for Ukraine and everyone else in the world. Thank you very much.
Thank you very much, Tanya, for raising those issues about communication. Without further ado, I'll hand the floor to Svetlana, and I'll ask her to stick to 10 minutes so we have a bit of time for Q&A. Svetlana, the floor is yours.
Thank you, Federica. I would like also to start by extending my sincere gratitude to the organizers for putting together this very important and timely event. Special thanks go to Professor Andrew Ford and to Dublin City University. It's a great pleasure and honor to join you today from Washington, D.C. In my short presentation, I would like to focus on 2 points. I would like to offer a different take on how we can interpret the divided reaction to the Russia-Ukraine war, which undermines significantly Ukraine's legal position. And I think I sort of will be building on what Tatiana has just said, but more from a legal perspective. And based on this interpretation, to offer some preliminary thoughts on how the community of international lawyers can proceed if they accept this interpretation plausible. There is no need to say that reasons for the divided reaction are varied and complex. Factors such as geopolitics, economic self-interest, shifting political alliances, or sometimes economic necessity are very important explanatory factors. But at the same time, very important factor has been how we use international law in the way we talk about the war and also in the way we're looking solutions for this war. I think that this also has contributed to the anticipated reactions partially, and it goes beyond claims of double standards and selectivity, which Ukraine and its partners have to deal with as well. What I mean that what is missed in the current attempts to build solidarity with the global South is their continued frustration with the failure of Western international legal mainstream to understand that certain international law norms, including human rights norms, do not work the way we hope them to work. And in particular, I mean the legal tradition of human rights skepticism, which influenced certain professional legal communities of the Global South in the moment of decolonization. This tradition, I don't think that it made any specific claims against Ukraine's legal offensive, but I think that it's helpful to think that they are certainly in the background, and they certainly influence and can partially explain the lack of sustained and enthusiastic endorsement of Ukraine's legal position. Because for this legal tradition, the focus on enforcement, on recommitment to multilateralism, human rights institutions and treaties, emphasis on litigation is helpful, but it's not enough, and is quintessentially rooted in the Western liberal legalism with its blind spots and biases, which exclude vulnerable groups, produce cultural hierarchies and economic inequalities. So what Tatiana said, that there are different actors in the world who care about knowledge production. So these groups of scholars cared about particular aspect of legal knowledge production. And what Russia did, the way I see it, it capitalized on these frustrations which existed long before Russia's aggression. So it's not only part of Russia's propaganda, although, of course, it is playing an enormous role. But what Russia has done, it exploited the language of a multipolar world vocabulary, which adopts and sometimes misuses and abuses this human rights skepticism, which was meant and is meant to make the human rights movements better. But unfortunately, what we see in Ukraine's struggle context, that this language is just misused. So to the extent this interpretation is plausible, it creates a double challenge for Ukraine and for its supporters to resist aggression, which is actual and which is real, and it happens daily. But at the same time, to acknowledge, to accommodate, to engage with this criticism of many aspects of international law, which are, in a way, in a certain extent, to build a transnational solidarity. Let me also say that I think it's fundamentally unfair to expect from Ukraine to address this double challenge. And I think that this is task precisely for the broader international community, and in particular, the Council of Europe, who undoubtedly has played an enormously important role in bringing human rights after the collapse of the Soviet Union, or I would say not bringing, but helping the communities, and especially in Ukraine, to fight. And I hope that this task can be realized. So efforts, to summarize, efforts aimed to bring Russia accountable with its focus on technical issues should go hand in hand with not letting Russia monopolize the language of multipolarity and the language of human rights skepticism. Ukraine is legally right and morally right, there is no doubt about that, and Russia's eclecticism in legal arguments might seem laughable at first sight. But at a closer look, Russia is striking the right chord with certain global South communities who are also sensitive to knowledge production, precisely because of this eclecticism. Russia talks the language of culture, the language of history, the language of injustice. All of a sudden, it's the West which interferes in post-Soviet republics' political autonomy, cultural autonomy, their own vision of democracy. This sounds absurd. In reality, it's Russia who imposes its vision of culture and political autonomy in the region, who absolutely denies cultural, social, economic rights and just the ability to do politics in Ukraine. So decentering Russia as the only cultural and political core is precisely what is in the center for ensuring long-lasting peace and stability in the region and in Ukraine-Russia relations. But I think that it has been enormously hard to make this point and to make this argument precisely because we usually tend to speak in the language of legal necessity. It's not that it's not right again, but I think that we just have to realize that when we speak the language of legal necessity or just the language of this is the fight of democracy versus autocracy, then we miss that this line of argument is open to charges of cultural imperialism, which is working against Ukraine and against Ukraine's legal offensive. So for this reason, I think it's also important to keep in mind that sometimes we might need to step away from the language of doctrinal and factual purity. Not that it's not important, again, it is very important, but also to acknowledge kind of the downsides of this very same language, how it can be misused and abused by Russia, not only through propaganda, but through the legal language. I don't think that, of course, it might bring more votes in the UN, but I hope that it can change the tone and character of how we discuss Ukraine's legal initiatives. And I think it's critical to open this possibility to undermine Russia claims and to undermine its position as the sole interpreter of what culture means or should mean, of what politics should mean or means in independent countries after the collapse of the Soviet Union. Thank you, and I look forward to our discussion.
Thank you very much, Svetlana, also for your remarks. And that leaves us around 10 minutes for a Q&A session. After that, we need to wrap up and hand the floor to the Polish Minister, Deputy Polish Minister of Justice. So I'm very happy to open the floor for questions. And again, I would like to ask people who want to speak to quickly introduce themselves and keep your question short. And in the meanwhile, I'll say bye-bye also to Michael Flaherty, who's leaving us with, again, thanks for joining us. So, Andrew, of course, you were excluded in the previous round, and I'm very grateful you're raising your hand now. So, Andrew Fort from DCU.
Thank you, Federico. This is a question for Sarah in particular, but others may well have an input on it. Sarah, it strikes me that one of the paradoxical features of our challenges of prosecuting the large-scale serious international crimes is actually paradoxically the volume of digital evidence, because there is just so much. I think one of the shocking things in early 2022 when the invasion was underway was it felt like it was in our living rooms. It was being played out in real time, and I really don't mean that to be offensive at all. I'm just trying to share that I think that's the perspective of many. So I just wondered, do you have any thoughts on that issue of you know, how helpful or unhelpful is it that there is just such an absolutely enormous quantum of digital evidence available? Thank you.
Yeah,
Sorry.
thank you. I'm sorry. Excuse
Feel
me.
free to respond directly.
Thank you. Thank you so much. This is a great question. To be honest, I agree with that it's a mess of different digital evidence, and it's very big challenge for different jurisdiction, I mean ICC and national courts, how to manage all of this evidence. And this is one of the sphere of activity of Truth House organization, because we collect this evidence according to the provisions of Berkeley Protocol, and we are responsible for result of our OSINT instruments, how we manage it and how we use it. And that's why we try to build big cases, and we have many markers when we start to investigate some episodes with using OSINT instruments. We try to choose something that national, for example, agencies can't manage by themselves, for not duplicate their stuff and what they do, but just according to complementary principle, to add and to collect some evidence that they need. I mean, ICC partners from ICC, and from prosecutors and investigative agencies in Ukraine. This is how we try to manage this big challenge, yes? And so that's what I can explain. And what about our national regulation? It's more formal frames, because in our courts, this is evidence need to be proved according some expertise by agencies who has which has license from our government to check quality of this evidence, electronic evidence. And this is more difficult, even if we transfer this evidence to ICC, for example, or to other jurisdiction. But that we have this big challenge, not we, but courts who need to value this evidence, yes? We understand that. And so for us, we guess that we need to limit these activities with focus on concrete episodes of violence and with concrete matters and goals. I hope I answer for a question. Okay.
If there are no further questions from the audience, I might abuse my position. I know, Tanya, you wanted to come back to this, but since you talked about communication, last week Trump called Zelensky a dictator. And of course, all newspapers said this is the disinformation communication bubble that Russia is creating, in which he leads. How do we deal with that? What can we do? And then you have the final words.
I mean, I think, this is a great example, and I would go back to, I think Svetlana said that, it's good to have facts. It's good to have like the legal process or whatever is like legally admissible. That's important. But I think it also then is important to also listen to kind of the people on the ground and to their experiences. And I think we saw some of this in response, to this wild claim, where obviously, there were lots of Ukrainian media and other international media who were immediately fact-checking this claim by talking about, the fact that Ukraine can't hold elections during martial law because that's in the constitution, but also then comparing, how many elections and how many changes of presidential power have happened in Ukraine in the past 20 years, and then comparing it to the US, Russia, Belarus, some other countries where, in Ukraine, we've changed 4 or 5 presidents in the past 20 years. In Russia, that hasn't really happened. It's still the same guy, and it's the same in Belarus, right? So technically, just if you just say something, right, you do need to fact check it. But I think the more important part was then to also see some evidence in the form of like surveys and polls from Ukraine conducted by multiple different agencies, saying that, Zelensky still enjoys popular support, but also talking to people on the ground in regions where active warfare is going on in other places, who are also explaining that, even if we would really love to hold elections, we can't, because that's just not possible. Like, it's just not feasible to organize the proper election process because there are missiles and bombs and drones dropping from the sky. So how do you take people to the polls? How can people in occupied territories vote in an election? How can the military who are serving vote in an election? And I think finally, right, even listening to some of the opposition politicians in Ukraine who said, well, yeah, obviously we don't like Zelensky, and we think we should have a new president, and we're definitely gonna be putting our policies forward, but we do think he's legitimate and he's not a dictator. And I think that tells you more about the legitimacy of Ukrainian democracy than anything. So it's the facts and then the voices of the people.
Thank you so much, Tanya. Let me thank very warmly Zara and Svitlana for joining us online. I would like to ask the whole room to join me in a big round of applause for what has been a fantastic conversation. I'll come back to the podium because we are moving to the very final session of this conference, and I believe online we are able to showcase on screen Dariusz Mazur, the Deputy Justice Minister of Poland. So as the Deputy Minister comes online, let me just say, ladies and gentlemen, that I am truly delighted to welcome the Deputy Minister of Justice of Poland, Dariusz Mazur, and I want to warmly thank him for joining us online. On behalf of Dublin City University and the Dublin European Law Institute, I want to express my gratitude to the Polish government for agreeing to engage with us for this event in the semester in which, of course, as you know, Poland chairs the presidency of the Council of the European Union. I also want to acknowledge that actually the DCU Brexit Institute already had the pleasure to host online the current Polish Minister of Justice, Adam Bodnar. That was a couple of years ago in the framework of our Jean Monnet network bridge funded by the European Commission. And at the time, of course, Adam Bodnar was the Polish human rights ombudsperson. But we're truly grateful that his team has offered to speak at this event. And we are extremely pleased that Minister Dariusz Mazur will deliver the concluding remarks. Let me just say that Minister Dariusz Mazur is Deputy Minister of Justice and formerly a judge at the Regional Court in Krakow. He chaired the 3rd Criminal Division from 2020 to 2020 and served as the coordinator of the International Cooperation and Human Rights in Criminal Matters from 2017 to 2019. He has been a legal expert and lecturer and was involved for many years in European judicial training networks. And among the many acknowledgements and prizes he received, I'm pleased to emphasize that he was named a European Judge 2015 and awarded the Badge of Honor by the Polish Judges Association called Justitia in 2020. So we are really fortunate to have you with us. I hope you can hear me well. We see you on screen. Therefore, without further ado, I'll hand you the floor. And again, thank you for being with us.
Thank you very much for giving me the floor. I hope you can hear me well. Dear ladies and gentlemen, honored participants in today's conference, we all show solidarity with Ukraine in the face of Russian aggressive war. At every international forum, we constantly recall the independence, sovereignty, and territorial integrity of Ukraine within its internationally recognized borders and its inherent right to self-defense. Naked aggression and brutal force cannot stand. We must aim at keep international order based on law, not on violence. I note with satisfaction that following the aggression of the Russian Federation against Ukraine and the subsequent decision of the Committee of Ministers to exclude the Russian Federation from the organization, the Council of Europe immediately adjusted its support to Ukraine in response to the national partners' requests and needs. The priority adjustments to the Council of Europe Action Plan for Ukraine 2018-2022 were adopted and implemented, thus contributing to the national reconstruction efforts guided by the government of Ukraine's National Recovery and Development Plan, aimed at rebuilding a democratic and prosperous Ukraine. This clearly shows that the Council of Europe remains fully committed to Ukraine's independence, sovereignty, and territorial integrity within its internationally recognized borders. In the contemporary world, especially in the face of Russian aggression against Ukraine, which is an expression of contempt for international law, it is necessary to respond to the current challenges quickly, firmly, and in coordinated manner. The transformation of the geopolitical situation provides us with an impetus to promote the peaceful resolution of disputes and to emphasize the role of law as the primary regulator of international relations. It is absolutely vital to continue supporting activities for peace, including the prevention and punishment of international crimes. It is therefore obvious that we should strive to strengthen the role of international courts, including the International Criminal Court. The International Criminal Court is the first ever permanent international court established to try perpetrators of the most serious international crimes: genocide, aggression, crimes against humanity. Poland ratified the Rome Statute in 2001, and it's actively cooperating with the court in building an international rule-based order. I'm pleased that Polish intervention in the Council of Europe regarding outrageous Russian attempts to intimidate judges and prosecutors of the International Criminal Court because of the arrest warrant issued for President Putin led to the firm condemnation of the actions of the Russian authorities. The aggressor is and must be publicly condemned and isolated. Russia, since the beginning of the present conflict, which arose out of her policy of aggression, has instituted in the occupied Ukrainian territories a regime of terror, characterized among others by genocide, war crimes, and crimes against humanity. Whereas these acts of violence are investigated by International Criminal Court and competent national authorities participating in the joint investigation team established on 25th March 2022, but International Criminal Court, which is a prime international institution for repressing international crimes, doesn't have at present, unfortunately, jurisdiction over the crime of aggression against Ukraine. Therefore, affirming that act of aggression against Ukraine is criminal according to the general principles of law recognized by the community of the nations and is a crime under national and international law, we must place among their principal aims the punishment through the channel of justice arranged in accordance with the international law of those guilty of this crime of aggression, whether they have ordered it, perpetrated it, or participated in it. Let's hope that we will see that in a spirit of international solidarity and in accordance with international law, Those guilty of act of aggression, whatever their position are sought out, will be handed over to the court of international character and judged, and that the sentences pronounced will be carried out. Russia's aggression caused numerous damages to Ukraine, its nationals and legal entities. We all know that according to international law, that the breach of international obligation involves an obligation to make full reparation in an adequate form. Therefore, Poland actively participates in the work of the Register of Damage caused by Russian aggression against Ukraine, established under the auspices of the Council of Europe. In my opinion, the key issue is now to fully and carefully document the damage caused by the Russian aggressor to the Ukraine cultural heritage. The register is intended to serve as a documentary record of evidence and information on claims relating to damage, losses, and injuries caused by Russia's aggression against Ukraine. Poland supports the International Center for the Prosecution of the Crime of Aggression against Ukraine with the joint investigation team created on 25th March 2022 and the creation through an international agreement of a claims commission for Ukraine, negotiations for which are expected to begin as early as March this year. I do believe that the conclusion of the agreement will contribute to building a better, safer, and fairer world. The issue of the unlawful deportation of Ukrainian children from occupied territories deep into Russia has become a matter of considerable concern and attention. This heinous act deserves the strongest possible condemnation and punishment. I wholeheartedly agree that every child, due to their physical and mental immaturity, requires special protection and care, including appropriate legal safeguards. Against this background, once again, I note with satisfaction that Council of Europe provides protection of the rights of Ukrainian children during and in a post-war context. In its project implemented within the framework of the Council of Europe Action Plan for Ukraine, Resilience, Recovery and Reconstruction for the years 2023-2026 by the Council of Europe Children's Rights Division, and in close cooperation with the Council of Europe office in Kyiv, it focused on protection and promotion of children's rights in view of the particular risks generated by the conflict for displaced persons, children without parental care, unaccompanied children, child victims or witnesses of violence, in line with Council of Europe standards. It focused on enhancing the effectiveness of frameworks aimed at child-friendly settings and procedures for investigation, as well as improving capacities of multiple professional target groups working with children. The role of the European Court of Human Rights cannot be overestimated. It has a huge responsibility to adjudicate not only in ordinary applications against Russia, lodged before its removal from the Council of Europe, but especially Ukraine's complaint concerning violation of the Convention for the Protection of Human Rights and Fundamental Freedoms as a result of the full-scale war started by Russia 3 years ago. In this context, it's to be noted with satisfaction that the court, in adjudicating the case of Ukraine versus Russia concerning Crimea, as well as the joint applications of Ukraine and the Netherlands against Russia, has abandoned the practice of limiting its jurisdiction by incorrectly interpreting Article 1 of the Convention, which allows for better protection of the interests of victims of armed conflicts. Although the Russian Federation ceased to be a high contracting party to the convention on 16 September 2022, it remains bound by obligations under the convention, including to implement judgments of the court in accordance with Article 58 of the convention, and the Committee of Ministers continues to supervise the execution of the judgments and friendly settlements concerned. By decision of Committee of Ministers, the Council of Europe has established a register of reparations awarded against Russia, and the total amount with interest as of February 21st this year exceeds 155 million euros in just two cases, Georgia versus Russia number 1 and 2, and the sum of compensations with interest in individual cases is approaching 3 billion euros. To conclude my speech, I would like to emphasize that the international legal system based on the European Convention of Human Rights acquires special importance in a situation where the global order is being violently disrupted before our eyes, which unfortunately may lead to weakening of the political mechanism for preventing human rights violations. Thank you very much for giving me the floor. It was a great honor. Thank you.
Thank you very much, Minister Mazur, for your remarks and for highlighting many of the points that we touched on across our day of engagement here at Dublin City University. Your keynote speech brings to a close our conference perfectly on time. But as the motto of the Dublin European Law Institute is food for thought, European law and policy, you can appreciate that after the food for thought, we now also have some food. So it is my great pleasure to invite you all for a reception that takes place at the Alberts College building. And I think if you just follow the crowd, we will walk you there. I also want to mention and acknowledge that this final reception, I think, is paid by the School of Law and Government. I want to thank the head of school, Tanya Niverhila, for kindly supporting us in this initiative. And finally, I think I want to call here at the podium for the very final word, my colleague and friend, Andrew Ford, who has been really the driving force behind this event. So thank you very much all. And Andrew, please come here for the final remarks.
I'll be extremely brief, only to simply say that it was a privilege today, I think, for all of us to bear witness to the multitude of perspectives that are relevant to this complex question and urgent question. I think amid all of the noise and kerfuffle of geopolitics in the last number of weeks that I think has shocked us all, it's easy to get derailed and distracted from what are fundamental legal questions around how do we actually ensure that this is not the point of meltdown of international law. So I think that today has certainly given oxygen to us all in terms of how we can move forward. It's obviously a very difficult situation, but there was a lot of very, very, very useful inputs. And I just want to simply say thank you all for your perseverance getting to this point. And actually one last point, sincere thanks to Charlie. If it wasn't for Charlie. So thanks again, thanks to AV, thanks to all the support, thanks to DFA and Tanya and Federico and everyone, my appreciation to you all. And please do join us in the Albert College. Thank you.